Yes.
Lord, I beg to mention item number 38, my lord. This matter will come after vacation, my lord.
38.
38.
What is the matter? Heard Mr. K. Singha, learned counsel for the petitioner, who prays for an adjournment of the matter. The prayer is allowed. Let this matter be listed after vacation on a date to be fixed by registry.
Yes, my lord, in criminal appeal, my lord, a 7-year conviction, my lord, petitioner in jail for 3 years, 3 months, my lord. A IA for bail is pending, my lord. Day after tomorrow, my lord.
Pray before registry. Registry to fix the date.
My lord, actually similar prayer. I also filed IA request on both of them.
Similar order.
But
Pray before registry.
what they are,
Registry to fix the date.
but they are declining to fix this before vacation.
No,
This
tell-
that's why I coming forward.
Registry will fix the date.
Not just because we moved there, we went, but this before vacation they declined.
You,
That is why we are approaching this, your lordship. Because on
No.
May 1st May itself it was
either I have to reject your prayer or you have to go before registry. Yes.
yes.
May it please your lordship, I am praying for listing of one bail matter for motion on 24th, my lord,
When have you filed?
on Friday, my lord.
Friday, it will be automatically listed. No date. Registry to fix the date. Yes.
My lord, here, my lord, an investigation, my lord, has been extended by, my lord, an order which is contrary to the law, my lord, under NDPS Act.
What is the prayer?
My lord, for listing, my lord, criminal petition, my lord.
Registry to fix the date.
I'm deprived.
May please the lordship prosecutor item number 30, we have filed an additional affidavit that will be brought to record, my lord.
All the affidavit.
My lord, I beg to mention an AB, my lord. That was, my lord, as per last order dated 24/6/25, my lord. It was supposed to be listed after the vacation, my lord. Last vacation, my lord, that is the summer vacation, but that has not been listed till date, my lord.
You are on interim.
Yes, my lord,
Interim.
interim, my lord.
Then registry to fix the date.
Lord.
My lord, I am praying for listing on criminal petition, my lord. Any date to be fixed by the registry before vacation, my lord.
Registry to fix the date.
And another matter, my lord, I am praying for listing on after vacation 14.
No urgency.
My lord, because the
After vacation, there is no urgency. You have to mention.
Last day, next date is 16. my lord.
You go before registry. Pray to registry.
Lord, after vacation on 14, I am saying. Because the last date.
No,
next
after
date is-
vacation, no need of mentioning. You may pray before registry.
I'm paying for a list on criminal petition, lordship, for motion lordship, last listed on 10th of September, but matter was left over, lordship,
Registry to fix the
on
date.
Friday, lordship, last listed on.
Yes, registry to fix the date.
Criminal revision petition.
Registry to fix the date. You pray before registry.
Yeah, please, your lordship. We can mention the criminal revision and both the parties have been mutually settled.
Registry to fix the date.
Nothing.
Lordship, fresh regular bail application.
All listing matter registry to fix the date.
May I please, lordship. Lordship, I beg to mention item number 11, my lord. The bail petition of the co-accused, my lord, listed before the court number 25 in hearing column. In that court, my lord, CD also received, my lord.
Item number?
11, my lord.
Item number 13 also same, my lord, same PS.
Who is the counsel? Item number 13 will pass orders when the matter is called. Item number 11.
Lordship, may I directed to, my lord, transfer this case, my lord,
Heard
number 25.
Mr. K. M. Hassan, learned counsel for the petitioner, who submits that in a connected matter arising out of the same police station case number, the case diary has been fixed. Case diary has been called for by a coordinate bench of this court, and the matter is fixed for hearing.
Today, my lord.
Learned counsel for the petitioner prays for listing this matter along with the said case. The prayer is allowed. List this matter along with bail application number
Lordship, bail application number 2913/2025.
2913/2025.
Today's list, item number 30,
Which court?
25, court number 25, item number 30.
Before the court where the said cases has been listed.
Lordship,
Please, your lordship, I beg to mention for listing a bail application for motion for Wednesday, lordship. In this case, what had happened, lordship? The petitioner has been arrested.
When have you
twice,
filed?
Lordship, today,
Registry to fix the case.
registry, lordship,
Yes,
before vacation, lordship,
pray before registry.
lordship. Oblige, your lordship.
Please, your lordship, I beg to mention item number 23, and the matter may be adjourned for
23.
3.
Heard. Miss
R. Shaheen.
R. Sahin, learned counsel for the petitioner, who prays for an adjournment. The prayer is allowed.
Can it be fixed on Wednesday?
No.
My lord, this bail application for withdrawal, my lord.
When?
Tomorrow.
Tomorrow.
May I please, your lord, I beg to mention for listing of anticipated bail on Wednesday, my lord, I have filed it on Friday. My lord, there are, my lord, some urgencies. my lord.
Registry to pray before registry.
109 section is the attempt to murder.
Pray before registry.
Lordship,
item number 5575.
Yes.
CD was called for lordship, CD not received.
Heard Mr.
Ace Islam on behalf of
S.
MK.
Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Learned-
55 first is submitted, my lord.
You are on interim.
Yes,
Yes.
We'll pass orders when the matter will be called.
May I please, your lordship? Lordship, I beg to mention criminal petition number 525/2025 for listing, my lordship.
Pray before registry.
Lordship, may I just pray one thing, my lord?
No, pray before registry.
Humble request, my lordship. Please,
Yes.
my lordship. Lordship, this honorable court passed an interim order for that our order that criminal proceeding before the family court have restored, my lordship. Lordship, this petition I have filed an affidavit in opposition 11/09/2025, my lordship. Lordship, I already approached the registry, my lordship, that mention, lordship, time.
You approach before now with the mention memo. Say court has asked to.
May I please, your lordship. I beg to item number 30, lordship. Criminal matter, lordship, to fixed on. 225 along with item 30.
Heard Mr. D.
Jehu
J.U. Ahmed, learned counsel for the petitioner, who submits that a connected bail application arising out of same police station case number has been fixed before a coordinate bench of this court, where the case diary has already been called for. He prays for listing this matter before the said court in pursuant to the prevailing notification of the registry. The prayer is allowed. Let this matter be listed before the appropriate court today, along with bail application number
2913.
double
2913.
2913/2020.
God bless.
May I please, your lordship? It is for listing of a criminal petition, lordship, filed today, your lordship.
Registry
Before
to,
vacation.
registry to.
May it pleases your lordship. Lordship, I beg to mention item number 18.
Yes,
Kindly adjourn the matter for the day.
heard Miss. What is your name? L.
L is
L. Izum, learned counsel for the petitioner, who prays for an adjournment. The prayer is allowed.
could the matter kindly come up on 26th of September?
No, you registry to list this matter on a date to be fixed by it.
Right.
Item 6 for withdrawal.
Piece of nothing.
Item 7.
You are withdrawing the criminal petition.
Yes, my lord, due to date of the petitioner, my lord.
Heard Mr. S. Rahman, learned counsel for the petitioner, who prays for allowing to withdraw the criminal petition along with the interlocutory application due to the death of the petitioner. Prayer is allowed. This criminal petition along with the interlocutory application is dismissed on withdrawal.
Okay.
I got instruction from the petitioner to do the. Well, I got the instruction from the petitioner to withdraw the petition.
Withdraw.
Yes, ma'am.
Okay. What is your name?
Yes, ma'am.
Heard Mr. K. Islam Learned Counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
But
Passed over for the time being, something is on next.
It is in why it has come in motion column. You have filed written objection.
Yes, Your Lordship.
Okay, we'll,
Receive the copy also. Last time it's not in record.
okay, we'll take it up after some time. After the motion matters are over.
Okay.
maybe listen, Lordship, kindly pass out the matter for the time being. Lordship.
What is the matter?
POXO 6 is there, one notice has to go, madam. And succeeded case, can
Yeah,
copy and notice.
Judge. Heard, Mister, what is your name?
Semandal.
S.M. Mullah.
Mandal.
S.M. Mandal, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. All for the scanned copy of the trial court records, as well as issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 30 October. After something.
Item 14.
May I please, Your Honor? Yeah, for it to be begin the application, this matter will be disposed of losses as the lordship has already observed that Kerja losses, one of the witnesses has granted bail by the Honorable Court. And Your lordship has observed that the chair incident was an accident, lordship, and FIR lordship can be page 9 lordship. What happened in this case, lordship, some persons lordship were enjoying party lordship, and one Biswajit Sarkar who accidental his pistol lordship.
Who are you?
I'm Biswajit, Dipanjit Fukonda. He has just joined the party, lordship. He's not role.
Yes.
Accident, lordship.
Yes, Mr. Parashar.
Yes, that day, Malat, it is, Malat allowed regarding Biswajit Saikia.
He don't know the
He
pistol.
He used the pistol.
used the pistol
Okay.
as per the order.
Heard Mr. T. Sutia, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Deepam Jyoti Fukon, who is apprehending his arrest in connection with Silapathar PS case number 176/2025 under section 118 within bracket 2 slash 118 within bracket 2 of BNS, read with section 27 within bracket 1 of Arms Act. the gist of accusation. Hmm. Learned gist of accusation already. Learned counsel for the petitioner has submitted that in this case, the accusation made is that when accusation made in the affair lodged by one Rituraj Das, officer in charge of Borborua police station, is that that on 20th August 2025 at about 10:35 PM, the police received a phone call informing, giving information regarding the fact that the caller is in danger and he asks for help. Accordingly, a police team arrived at thereafter 4 individuals arrived at the police station in a Fortuner car and informed that one Ganesh Lal Kumawat had sustained gunshot wounds due to accidental use of a pistol by one Bishwajit Soikia. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the accusation made in the affair. However, he fairly submits that he was also there in the party where accidental gunshot occurred. Stop. Learned counsel for the petitioner submits that in the meanwhile, the person responsible for accidental gunshot, namely Vishwajit Saikya, has already been granted bail by this court in bail application number 2883/2023 on 16/9/2025. Stop. He further submits that the police is searching for the petitioner and therefore he is apprehending arrest. He, however, is willing and ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that in this case, after perusal of the case diary, the one Vishwajit Soikia, who accidentally used the pistol from which gunshot was made, has already been granted bail. Stop. Considering the submissions made by learned counsel for both sides, this court is of considered opinion that if the petitioner cooperates in the investigation, his custodial detention may not be necessary for fair completion of investigation of Silapat RPS case number 176/2025. Accordingly, the above named petitioner is directed to appear before the investigating officer of the aforesaid case and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. This anticipatory bail application is accordingly disposed of.
I'm sorry, my lord, I did not reach in time. Item number 12. Only case diary, my lord. And notice will be there after vacation, my lord, reopening. Item number 12. Also is there, my lord. Notice
Heard
not-
Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. K. Parashar. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry. The petitioner shall take steps within
16,
3 days from the date of this order. Returnable on, yes,
1610, my lord.
1610. List accordingly.
Keep your-
Right, clear. My lord, this is the first time application, revision application against an order passed by executive magistrate for opening a road, my lord, over the land of the petitioner who are the exclusive owners in possession of the land. At this stage, I pray for eventual notice on
Heard Mr.
next measure.
N. H. Majar Bhuya, learned counsel for the petitioner. State is a party.
Yes,
Yes, has been main party, but the PP has not been shown, my lord, in the Cosby also, my lord. A copy also not given to us. This is not a WB criminal, so it is a criminal revision. So PP,
Here, state should be, copy
PP.
should be given to the
PP, my lord.
public prosecutor.
Just 6 secretary of law.
This application under section 438/442 of BNS has been filed by the petitioners impugning the order dated 30/7/2025 passed by an additional district magistrate Dispur Code District in case number 9/2025 under section 152 of BNS. Issue notice to the respondents. The learned additional public prosecutor submits that since this is a criminal revision petition, the notice ought to have been served on the public prosecutor. The petitioner is directed to serve notice on public prosecutor also. As regards other respondents, the petitioner shall take steps for service of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 3 weeks. List accordingly.
16. The revision petition against the impugn order 28/7/2025 at page 26. Showing the learned court didn't call for the material witness and the matter was fixed for arguments. Lordship, while the PW7 has given you evidence before the court, which is at page 29. It was
Which is the impugn order?
Lordship at page 26,
Which order?
28/7/2025. The evidence was being closed and it was fixed for SDN arguments.
Yes, what
Now,
happened?
Lordship, we wanted the evidence of Niren Bora and Bipin Bora as been given in the page 29. The PW7, that is the SI Parthapratim Gogoi, has categorically mentioned in this.
No, where is your prayer for calling them?
No, Lordship, actually one.
What is the error in this order?
The Lordship, the 29 number page wherein the the SI Parthapratim Gogoi in page 30 has specifically mentioned, I have recorded the statement of Niren Bora and Bipin Bora. And this prosecution witnesses has not been called for.
Where is your prayer before?
No, Lordship, we could not give a prayer because the matter was,
So
the order was already been passed. The argument has been, it was fixed for arguments. So
there is no error, apparent error in the impugn order.
since the evidence was being closed and it cannot be revised,
by the court, so we could not give any application therein in the court.
But there is no error. This is a revision petition.
Yes,
So you show the irregularity or error which is apparent from the face of record. There is no error.
for the fair justice and fair trial, your lordship. This
You have
thing-
not prayed before the trial court for recalling any witness. If
Because the evidence was already being closed and we could not give a further application therein.
you, unless you file an application, you cannot directly come before this court. There is no heard,
Actually, direction may be given so that we can give a application.
no direction. You heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 437, 438/442 of BNSS has been filed by the petitioner Nurul Jaman, who is facing a trial under section 376 within bracket 3 of IPC read with section 6 of POCSO Act, whereby the petitioner has impugned the order dated 28/7/2025. Stop. By the said order, the trial court has closed the evidence of prosecution witnesses and has fixed the case for examination of the accused and for arguments. When is the next date fixed?
If the date, I do not have the exactly next day, the last date was gone 11/8. I don't have the exact.
Learned counsel for the petitioner has submitted that the trial court has closed the prosecution with examination of prosecution witnesses without summoning whom?
The two material witnesses, Bipin Bora and
Without summoning
Bipin Bora and Niren Bora.
Bipin Bora and Niren Bora, whose statements were recorded by the investigating officer during investigation. Stop. On bare perusal of the impugned order, it appears that apparently there is no irregularity or illegality in the said order. On a specific query posed by this court to the learned counsel for the petitioner as whether any application was filed by the petitioner before the trial court for summoning the aforesaid witnesses. The learned counsel answered in negative. Stop. The prosecution side has the discretion to examine witnesses which it seems necessary for bringing home the charges against the accused. The accused cannot compel the prosecution side as to which of the witnesses are to be examined as prosecution witnesses. This court therefore does not find any illegality or irregularity in the impugned order. The impugned order is This criminal revision petition is accordingly dismissed without issuing notice.
হ্যাঁ, please, also, this is a criminal division petition, Lordship. Against the judgment and order dated passed by the learned additional session judge Golaghar on 2nd of August 2025, Lordship. Uh, the petitioner convicted under section 498A of IPC, Lordship, the impugned judgment and order is page number 29.
What are your grounds?
So the ground is that, Lordship, there is no any eyewitnesses, Lordship, regarding the alleged occurrence, Lordship, and also the prosecution also fails to produce any independent witness, Lordship. All the witnesses are their relatives, Lordship.
Those things cannot be examined in revision petition.
Otherwise, 498 के मतलब तो notice should go, मतलब
Okay,
498.
heard. What is your name?
DJ Boro, Lordship.
DJ,
Boro.
DJ Boro, learned counsel for the petitioner, also heard. Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438/442 of BNSS has been filed by the petitioner, namely Sharat Bora, impugning the order dated 22/8/2025 passed by the Court of Learned Additional Session Judge Golaghar, whereby the appeal preferred by the present petitioner against the order dated 8/5/2018 passed by Learned Judicial Magistrate First Class Golaghar was in GR case number 1676 was dismissed. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode. Let the records of the trial court as well as first appellate court be called for registry to take steps for issuing or requisitioning the trial court and first appellate court records. Issue notice of lickable, returnable after 4 weeks. List accordingly.
There is also a notice, till then, Lordship, stay the execution of the.
What is your ground? No stay. Let the record come.
19.
May I please, Lord? Herein the petitioner, he is the accused in the complaint petition filed by the respondent, Your Lordship, under section 138 of NI Act. Then my page 20, Your Lordship. Page 20. Herein 1,000 rupees cost has been imposed, Your Lordship. Because on that day, the petitioner failed to appear in the court.
You pay, otherwise you may have to pay more costs.
The
For
ground-
1,000, you have rushed to High Court.
The ground for
Where is
adjournment,
the,
Your Lordship, can be-
where is the impugned order?
page 20, Your Lordship. I'm reading the para number 4, Your Lordship.
Yes.
Since the petition number so filed by the learned junior counsel, wherein she has stated that his senior counsel is gone to Guwahati for medical treatment of his wife and prayed for another date for proof examination. It was the ground, Your Lordship.
No, ground
it
may
was
be
not-
okay, but the loss suffered by the complainant has to be compensated.
But-
You cannot say that you can take adjournment and you will not
But on
compensate.
that day, Your Lordship, only the respondent who is the complainant, he was only the present, Your Lordship. Except him, no witness was there, Your Lordship.
No, but for,
Basically, hearing your lordship for the problem of the engaged council, your lordship, this adjournment petition was filed. And it was.
for
not-
the problem of engaged counsel, there, you cannot claim that cost may not be imposed. Oh, where is the irregularity in this order?
Irregularity means, lordship, on the day, your lordship, the council the conducting council, he was out of station. And
Therefore, the adjournment was allowed. It is not a case where adjournment.
adjournment was allowed, but the cost is given, your lordship.
Yes.
I am only on that part, your lordship, that
You have to pay cost for adjournment. Adjournment cannot be. There was no fault on the part of the complainant. Fault was on your part.
yes, yes.
So you have to compensate.
I admit it, your lordship, but the fact is that, your lordship, for having problem of the council, your lordship, on that day,
You cannot claim that for council, problems of council, if adjournment is given, cost may not be imposed. There is no illegality or irregularity in the order. Heard Mr. A. M. Khan, learned counsel for the
I
petition.
am only, your lordship, the cost part, your lordship, I am only saying, your lordship, if your lordship can interfere with
No.
your lordship.
No,
Because, but what I got instruction that, your lordship, the wife of the engaged council, he was suffering.
therefore you are allowed. It is not a case that adjournment was,
It's allowed, but the cost part, your lordship.
cost you have to pay. There is no illegality in that order. Also admits. No. This application under section 438/442 of BNSS has been filed by the petitioner, namely Indrajit Boro, who prays for Indrajit Boro, impugning the order dated 29/7/2025 passed by the Court of Learned Chief Judicial Magistrate Siraj in NICR case number 17/2025, whereby an adjournment cost of rupees 1,000 was imposed on the petitioner. The learned counsel for the petitioner has submitted that on 29/7/2025, when the NICR case number 17/2025 was fixed for cross-examination of the prosecution witnesses and the complainant was also present, the present petitioner filed an application seeking adjournment on the ground that the engaged counsel has gone to Guwahati for medical treatment of his wife. The said cost was, can I act some? Said prayer was negotiable instrument. What is 143 within bracket 3? Read it. The adjournment was allowed. However, with a cost of rupees 1,000 to be paid by the petitioner to the respondent on the next date fixed. The learned counsel for the petition, please read it.
Every trial under this section shall be conducted as expeditiously as possible and endeavor shall be made to conclude the trial within 6 months from the date of filing of the complaint.
Stop.
Complaint.
Learned counsel for the petitioner has submitted that the petitioner is aggrieved mainly due to imposition of cost as the ground for which adjournment was sought for was a genuine ground. Stop. I have considered the submissions made by learned counsel for the petitioner. The perusal of the impugn order has on perusal of the impugn order, it is apparent that the state order was passed by the trial court in light of the provisions contained in section 143 within bracket 3 of the NI Act 1881, which mandates the trial court to complete the trial within 6 months, within a period of 6 months, 6 months from
The date of
filing of the complaint,
complaint.
from the date of filing of the complaint. This court, the the normal rule while granting adjournment is that cost shall follow the adjournment. Grant of the adjournment prayer. However, the petitioner is claiming that he is only aggrieved by imposition of costs. On the other hand, also seeking, on the other hand, it is he who sought for an adjournment. Stop. This court finds no illegality or irregularity in the impugn order so as to invoke its divisional jurisdiction to justifying interference in the impugn order. The instant revision petition is devoid of any merit. Accordingly, same is dismissed.
May I please, Your Lordship? Lordship, this limited prayer, Lordship. There is, before going to the impugn order, Lordship, first I'm giving the gist of the case, Lordship. This petitioner is the accused person in the NI case, Lordship, which was filed by the respondent and pending, Lordship, in Barpeta. Accordingly, Lordship, this petitioner appeared and, Lordship, cross-examined the prosecution witness. Thereafter, he himself examined as a DW1. Thereafter, Lordship, the respondent who relied upon it, Lordship, registered sale deed of agreement. In that state of sale agreement, Lordship, it was mentioned that some number of checks were issued to this petitioner, which indeed was not issued to this petitioner, Lordship. It was done by some other person. When, Lordship, this matter came to the notice of this petitioner, he filed an application before the trial court stating that this check number which has been mentioned in the registered deed of agreement is not done by me, rather it was done by some other person. When, Lordship, his name, it was the person who drawn the check is Narmada Das. Accordingly, Lordship, this petitioner filed an application praying the learned trial court to call for the said Narmada Das to examine herself whether the check which is mentioned in the deed of agreement was withdrawn by her or not. That was, Lordship, rejected. Then, Lordship, this petitioner filed the next application. That application, Lordship, will find at page 30. Page 30 is a small application, simple application. Page 30, Lordship, will get it.
There is no page 30 in your petition.
30.
Last page is page 29.
And I'm sorry, Lordship, might be some mistake is there, but I have the page number 33.
So,
So, Lordship, can after application, I will rectify the petition.
heard Mr. J. Kalita, learned counsel for the petitioner, who prays for an adjournment on the ground that there are some defect in pagination in the criminal petition filed by him, and he's praised for allowing the petitioner to rectify the same, and if necessary, to file an additional affidavit. The prayer is allowed. Let this matter be listed after puja vacations on a date to be fixed by registrar.
May I please, Lordship? My lord, may kindly see the FIR. That is, my lord, page 17. Property portion, page 19. In FIR, there is no name of any person. Now, we have annexed the statement adduced before the police by 8 witnesses under section 161, that is 180 of BNS. So those lordship may kindly see page 32.
Yes.
In page 32, lordship would see, I am my lord Tofajjal Haq. Now in page 19, there is no name. Now regarding the statements of the witnesses, page 32, there lordship would see, the first witness is Rahul Jain. He did not implicate me.
What is your name?
My name is Tofajjal Hussain.
Tafajjul Hussain.
Now, lordship may kindly see, this is the first witness. The next witness, Anil Kumar Jain, page 34.
Yes.
He has also not implicated my name at all. Then lordship may kindly see page 35. This is Saurabh Jain. So they are the sons and nearby persons where the alleged murder took place. This person, this is Saurabh Jain, he has also not implicated my name. Then lordship may kindly see page 37. This is the Hafizur Rahman. He was present at the place where the alleged murder took place. Now, he has also not implicated my name. He has said that, that's because he is the independent witness, and said that may be kindly see page 37 bottom. I doubt that Anwar Hussain alias Boga, Chor, thief of our village, and his company Pranab Das of Birja, Borkusi, Javed Khan, and another jointly killed the person. So he has mentioned certain person's name, but those are not I. Similarly, lordship may kindly see page 38, that is Joel Majumdar. Page 38, bottom kindly see, in top he has said nothing, but in the bottom he said that I have seen that Anwar and Pranab, along with their company, were suspectedly moving around the Vijayanagar Bazaar since 1 week, 10 days. So that those are also not I. Then lordship would kindly say page 39, Puruna Majumdar. Puruna Majumdar has also not suspected me, but he has said, bottom,
I doubt that the bike thief Boga of Holigao, accompanied by other partners, shot Shantilal Jain and took his money back. So I am not that Boga. I am not that Boga. Similarly, Lordship may kindly see page 41. This is Anil Kumar Jain. He has also not implicated my name, but in that bottom he has said, Bogachor thief and his partners were roaming at Vijayanagar Bazaar for few days. I doubt that he killed my father. Now, everybody is saying Boga. Nobody is saying Tafaddal Hussein's name. And in the particular part of the witnesses' statements, I have annexed. And page 44, it is Forest Talukdar. He has also suspect. Kindly see bottom of that page 44. I suspect that Bogachor.
Now, what other evidence is there? Apart from statement of the witnesses, is there any other forensic evidence, scientific evidence, CCTV? Why charge sheet has been filed against you?
Charge sheet has been filed, my lord, only on suspicion. Only on suspicion. That we have
What is
also
it?
annexed charge sheet.
What is the stage of the trial?
So it is the stage that now the latest CJM has referred the matter, transferred the matter to latest session just for trial. Because 392 is there.
If there is no material, you pray before the trial court for discharging you. Why this court should interfere?
No, normally, my lord, trial court says that let witnesses be examined.
No,
But our submission is this, Lordship kindly. bear
whether
with me.
charges have been framed or not.
No, not yet framed.
Consideration of charges.
That's next day. Next day.
You plead your case before the trial court. If there is nothing, then you will be discharged. Why this court should interfere? Why this court should exercise? Merely because you have approached.
First thing, this court has the power.
It has to be exercised very sparingly.
Sparingly, yes. But sparingly does not say that power should never be exercised. Power should be exercised in appropriate case.
Okay, then we have to peruse the case diary. We don't know what material you have produced and what other materials there may be in the case diary. You have only produced the statement of witnesses. There may be other forensic materials.
Forensic means by forensic.
If what you have shown is the only case, then it is a case for discharge. No materials.
And Malat, there may be some other witness also, Malat, which are.
We don't know.
We don't know, Malat.
Even if a single witness is there.
Records kindly for that Lordship examine because wastage of time, that's why.
You are wasting time here. That is the wastage of time. Had you pleaded your case before the trial court?
I'm a filming of.
No, that I have not done. But thing is, this court has the power. That is why I have come. Law has given me the right. So I have exercised that right.
But law is also that the power should be exercised very rarely.
That is also there.
You know that.
But for the time, Lordship may kindly
Heard Mr.
examine the records.
Heard Mr. M. Ahmed. This is item number?
21, Malat.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application has been filed, this application under section 528 of BNSS has been filed by the petitioner, Tafazzal Haq, praying for quashing of the proceedings of Sessions case number 92/2025, pending before the Court of Learned Session Judge Kamru
Amin Gao, just Amin Gao.
Amin
Amin
Gao. Stop. Issue notice to respondent number 2 and call for the scanned copy of the case diary of Palashwari PS case number 30/2018 from the trial court. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. The registry to take steps for requisitioning the scanned copy of the case diary. List accordingly.
All right.
Item 22. My lord, here in this criminal petition, we are challenging, my lord, judgment of honorable principals of family court, wherever, my lord, that the maintenance has been enhanced, my lord, 3,000 at a time now. From 6,000 to 9,000, it has been enhanced.
What do you do?
My lord, I was my lord employee of NABARD, my lord, grade 4 employee. At that my lord, at that moment of time, I was drawing salary rupees, my lord, 68,000. But presently, when the judgment was passed, my lord, I have been retired, and I'm getting, my lord, pension of, my lord, only rupees 36,000. That has been admitted by this.
Okay, we are issuing notice.
My lord,
Heard Mr.
BK Das, my lord. Kindly, my lord, in the
Heard
next day,
Mr. BK
Das, my lord.
BK Das, learned counsel for the petitioner.
My lord,
Also heard,
kindly, till the next date, my lord, that judgment may be stayed, my lord.
also heard Mr. KK Parashar, learned public prosecutor, additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Dhiren Chandra Medhi, impugning the order dated 19/8/2025 passed by learned Principal Judge Family Court number 2 in Miss Case number 293/2021, whereby the maintenance allowance given to the respondent by the petitioner has been enhanced by rupees 3,000. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by registered post with AD as well as by usual mode. The petitioner shall take steps within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
My lord, can be, my lord, that till next date, my lord.
Why?
Because, my lord, lordship, that 6,000, my lord, I am regularly paying.
You have to pay only 3,000 more for a month only.
My lord, there is
The-
some, my lord, lordship, just for a moment, my lord. Just kindly turn the page 52. my lord.
No interim without hearing the,
Well, only till the next date. Otherwise, I will have to pay the enhanced rate, my lord. That's why.
you
I'm saying.
pay enhanced rate.
My lord, I cannot, my lord, that all the evidences I have submitted, my income has been reduced from 68,000 to 36,000.
Then wait
admitted.
till the service of notice on your wife.
My lord, till the next day.
No,
No, yes,
Should
my lord,
I-
service of-
should-
service of notice, my. Otherwise, that I will have to pay that date is perhaps on next week. I will have to pay or the enhancer. My lord, I have, my lord, after divorce, my lord, I have, my lord, I have been married to another wife. She is undergoing some treatment, my lord. She is suffering from cancer, my lord. I have produced all these documents considering that aspect, my lord.
no interim.
My lord, kindly till the next date, my lord.
Should I reject it?
No, my lord.
Then
I am only placing my
you
arguments.
wait. No interim.
6,000 I am paying, my lord. 6,000.
The prayer for interim relief shall be considered only after due service of notice on the respondent number 2. Yes,
This is the Zimma petition, your lordship. And the rejected order is of the trial court is page number 19. And the petitioner is not the,
DPS.
petitioner is not the accused person in this case, your lordship. And your lordship, she is the widow, and this is the only the income source, your lordship. And the original registration is, I have annexed in page number 18.
Why your prayer was rejected?
Lordship, on the page number 19, your lordship, the presence of such secret chamber goes to show that this vehicle must have been used to smuggling contraband or earlier occasion also. But here not mentioned that which cases they have find this vehicle. The requested owner of the vehicle may be required for investigation. Having so considered the fact, I am not inclined to release the vehicle to the registered owner. This is the.
Yes.
Between the fuel tank and the upper body, there is a secret chamber and receiving the owner. Where
It is pending investigation. Whether investigation is going on
This
or
is the order of dated 27.
no, no, whether charge sheet has been laid in this case or it is. Because we have to peruse the case diary.
yeah, this is city perhaps not submitted of 30th of July. Commercial quantity.
Okay, okay, you produce the case diary. Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Sanjukta Banerjee, who is impugning the order dated 27/8/2025, whereby the prayer for grant of Jimma of the seized vehicle, of which the petitioner, you are the registered owner,
Yes, Your Honor.
of which the petitioner claims to be the registered owner, was rejected. Learned additional public prosecutor submits that since this case involves commercial quantity of contraband, the case diary may be perused
City along with a report of the IOM.
along, and a report may be called for from the investigating officer as regards prayer for grant of Jimma by the present petitioner. Let the case diary be called for. Let also a report be called for from the investigating officer as to whether Jimma of the, whether he has any objection in grant of Jimma of the seized vehicle to the present petitioner. Release this matter on 27th October.
Bless.
Item 25.
Please lordship. So this is a criminal petition filed under section 528 of PNS for quashing an FIR and charge sheet filed in connection with Dhemaji PS case number 24 of 2025. Well, the fact of the case is that well, the petitioner number 1, actually this case has been arising after a domestic violence case. Well, the petitioner number 1 is the legally married wife of one Biju Buragohain, who is the brother-in-law of the complainant. The petitioner number 1 and his husband has been living separately and they have a minor daughter aged about 11 years. In this collection, a domestic violence case has been already filed by the petitioner number 1, my lord. And that the minor daughter was in the custody of her mother till 23rd October 2024. But on 23rd October 2024, the minor went to meet her father and did not return. Then, my lord, the petitioner number 1, who is the mother of the minor daughter, and his mother went to see her daughter at her husband's house. So then, my lord, the respondent complainant has filed a CR case before the learner, JMFC Dhemaji. And that under section 296, 329, and 74 of the BNS. The 329 is the house trespass. And my lord, in a domestic violence case, when the Honorable JMFC passed an order also to meet her data, it is in page number 36, page number 36.
On what ground you are challenging the
FIR on the ground that my lord, this case has been filed under section 329, that is house transfer. My lord, I am the legally married wife of Mr. Biju Buragwai, and I have been residing at that house. And the honorable court also directed me to meet my daughter. Then I went there to meet my daughter.
What is 296?
296, my lord, that is enhance the public place.
117?
Actually, that has been 117, actually, my lord, I have to see. Actually, in the search sheet, 117 has not been invoked.
74?
74, that is outrageous modesty of a woman. That is, my lord, I am going to say that in the complaint, what is filed before the land judicial magistrate, the complainant has stated that his minor boy was assaulted by the accused. But my lord, here it is invoked that 74, section 74 has been invoked.
What stage the case is pending?
Consideration of trial.
You have appeared before the
My
trial.
lord.
Okay. Heard Mr. M. Hendek, Learned Counsel. Also heard Mr. K. Parashar, Learned Additional Public Prosecutor. This case, this application under section 528 of BNSS has been filed by the petitioners, namely Kashmi Dihingia, Senehi Dihingia, and Purnima Bora, praying for quashing of the proceedings of PRC case number 173/2025, arising out of Dhemaji PS case number 24/2025. Now, call for the scanned copy of the trial court record as well as scanned copy of the case diary of Dhemaji PS case number 24/2025 from the trial court. Also issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Also, may kindly consider my in
No such urgency is there. Let the record come.
Item 26.
Made this your lordship. In this latter lordship, I have instructions to appear. I filed my Wakalatnama for respondent number 2 lordship. Lordship, here the matter was already settled between the parties in the month of February of 2025, lordship, 6th of February. On the basis of which lordship, there was an agreement. But before the filing of this washing petition at page number 34, lordship, that an amount of 1 lakh has to be paid, lordship. But there is some more disparity between the parties. So may I pray, lordship, let the matter come after the vacation. Meanwhile, lordship, if there is a possibility of reconciliation between the parties. lordship, let us
Yes,
sit
what do
together.
you say?
Any objection, your lordship, let him take instructions.
Heard Mr. What is your name?
Durga Shankar Singh, DSC.
D.S. Singh, Learned Counsel for the petitioner. Also heard Mr. H. Betala, Learned Counsel for the
Respondent 2, lord.
respondent number 2. It is submitted at bar that there is a possibility of both the parties reaching an amicable settlement in this case. And therefore, a prayer for adjournment has been made. The prayer is allowed. Let this matter be listed after Puja vacation on a date to be fixed by registry.
And the PO, lord.
चलो
27.
मैं तो लिख दूंगा मैं तो मुझे पापा को टाइम नहीं
Item 28. Item number 28.
None has appeared for the petitioner on call. The registry to list this matter on a date to be fixed by it.
Item 29.
May I please your lordship? My lord, the petitioner before your lordship is a appellant in criminal appeal number 25 to 25. In the court of the additional session judge, Chittagong, and it is pending now. I have filed the appeal against the judgment and order dated 2/6/25 passed by the convicting the petitioner accused.
You are the complainant or accused?
Accused, my lord.
You are accused.
Yes, my lord. I have filed an appeal. I have been sentenced to pay rupees 9,33,000 in default to undergo imprisonment for 9 months and 10 days. Okay. By order dated 26/6/25, the appellate court has passed the order dated 26/6/25 in criminal appeal number 25. It is at page 43, relevant page 44, my lord.
Why are you impugning? You are impugning that order.
I am impugning this order in this petition along with the order dated 4/8/25 at annexure 4 at page 49. And to 50 to 51, 50 to 51, yes. In this, I am reading, my lord. Page 49 of last portion. On page of the order dated 26/6/25 passed by this court, however, discloses that by the said order, this court, while admitting the appeal, had considered the pair of the appellant made under section 431 of the BNSS, wherein the appellant prayed for suspending the judgment and sentence of the learned SDJM passed by order dated 2/6/25 and to admit the appeal and also to grant bail to the appellant. This court, after considering the same, admitted the appeal and also passed an order staying the execution of the sentence passed by the learned court below on condition that the appellant shall deposit 20% of the fine compensation amount imposed by the learned trial court below by the impugned judgment within 60 days from the passing of the order, and also allowed the appellant to remain on his previous bail. Such order directing the appellant to deposit 20% of the fine compensation amount imposed by the learned trial court was passed this court in exercise of the powers under section 148 of the NI Act, and not by way of interim compensation as envisaged under section 143A of the NI Act. Be that what it may, the appellant in course of admission, hearing of the appeal, never made any prayer for relaxing the provision mandated under section 148 of the NI Act, when the appellant made the prayer for suspending the sentence passed by the learned court below, so that this court could consider the grounds on which the appellant seeks relaxation of the condition envisaged under section 148 of the NI Act. Then again, when this court has already passed an order directing the appellant to pay 20% of the fine amount by order dated 26/5/25 on condition of suspending the sentence passed by the learned trial court below, and also to allow the appellant remain on his previous bail, this court now at this stage has no power to review its own order which has already been passed before the filing of the present petition 884 of 25. In the above circumstance, the petition filed by the appellant for reconsidering the order passed by order dated 26/6/25 is rejected. My lord, while admitting the appeal, the learned appellate court has suspended the sentence on condition to pay the fine and till next date fixed by the appellate court. And also, this appellant was allowed to remain on previous bail till next date. Now, therefore, and before your lordship, I beg to pray that the accused appellant may be allowed to remain on previous bail till disposal of the appeal and to suspend the sentence till disposal of the appeal.
You have paid.
Regarding the payment, I beg to submit before your lordship that payment of fine was imposed under section 148 of the NIA. This is the amending provision. This is a discretionary provision, not a mandatory provision, my lord. It is said that the appellate court may order the appellant to deposit.
But that has been exercised, that discretion.
My lord, it may exercise or may not be able. This is discretionary power of the appellate
So
court.
you're
Therefore, I am impugning that order in respect of that reaction also. So your lordship may kindly.
You have impugned that order in the month of September. The order was passed in June.
However, I am filed this petition under inherent power of this honorable court.
So inherent power, unless you are diligent, if you are aggrieved, you should have come before the court immediately.
I am impugning the order that I have filed the appeal on 26/25 and order was appeal was admitted on 26/6/25 in June. Thereafter, next dates were fixed by the appellate court.
When is the next date before it?
On tomorrow, my lord, 23/9/25. So I beg to pray before your lordship that the notice will be issued.
What is the illegality in the order? What is the illegality?
My lord, the condition that has been imposed, I am aggrieved, my lord. So that may be considered by this. The 148, section 148 of the NIA does not provide any provided for any condition, imposition of any condition for suspending the sentence. And so
Heard. Mr. D.K. Kotoki, learned counsel for the petitioner, also heard. State of Assam is the third. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Thankar Gogoi, impugning the order dated 26/6/2025, passed by the Court of London, Additional Session Judge Sibsagar in Criminal Appeal number 25 within bracket 2/2025, whereby the first appellate court directed the petitioner to deposit 20% of the fine amount within a period of 60 days. as a condition precedent for suspension of the sentence imposed on the petitioner by the judgment and order dated 2/6/2025 passed by learned Subdivisional Judicial Magistrate Nazira in NI case number 1/2024. And also as a condition for allowing the petitioner to remain on bail of the issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
My lord, I beg to pay for your lordship that till disposal of this petition. in the
No,
interim, the
Let
further
the
proceeding,
respondent appear.
till returnable of the.
No. Let the respondent appear. You approach this court after lapse of 60 days time, which was granted to you by the trial court, by the appellate court. You have approached this court much beyond the time granted to you by the appellate court. Therefore, not without hearing the other side.
Till then, my lord, further proceeding of
No.
this appeal. may
This
be
is
stayed.
not a case. Next item.
Accused may be allowed to remain on previous bail, my lord. That may be
Okay,
granted.
yes. Till the. But subject to your following of the condition imposed, you pay that money.
I am coming in respect of that order. Therefore,
No,
that may be hard, my lord.
No interim. You satisfy the trial court. No interim now. After service of notice to the respondent only, interim shall be considered. Your conduct is not. You approach this court, you allowed the period granted by the trial court to lapse. 60 days time was
Not
granted.
the trial court, my lord, it is the appellate court.
First appellate court.
Yes,
The
my lord.
appellate court granted
And
you
in
60
the
days.
appellate court, I have paid before the appellate court for relaxation of that condition of payment. I have filed, it is my petition. 60 days plus 90 days time. Oh. 60 days plus 30. I have filed my prayer before the appellate court, my lord. So.
Where is that prayer?
Not in Annexer 3 at page 45.
When you have played?
Yeah, on 25/7/2025. The petition number 884 of 25 at page number 45. Which has been rejected by order dated 4/8/25 by Annexer 4. It is at page 49.
Paragraph. You did not mention about this.
Sorry, my lord.
Learned counsel or submission of. Learned counsel for the petitioner has submitted that the petitioner had impugned the aforesaid order of the trial court by referring an application on 25/7/2025 for relaxation of the condition imposed for condition imposed by the appellate court while suspending the sentence, showing certain reasons for it. However, the appellate court by its order dated
4/8/20.
4/8/2025 has rejected the prayer for reconsideration of the aforesaid condition. In this revision petition, the petitioner has also impugned the aforesaid order. তার পিছত issue notice and suspense. Considering the fact that the contentions raised by the petitioner in this criminal petition deserves consideration, the operation of the impugned order dated 26/6/2025 passed by the appellate court, passed by the Court of Learned Additional Session Judge Sibsagar in criminal appeal number 25/2/2025 is suspended till next written number date. Give a fixed date. Let this matter be listed on 27th of October.
Oh, alright. My lord, I'm extremely sorry. My item was 28.
Wait for
Another
it.
court, my lord.
You wait, you cannot
My,
come and
just now it is over, my lord. So, my lord, I express my apology, my lord. I was in.
it will be called.
Party.
Next 28th. 27th. Yes.
Lordship, before going to the my grievance, Lordship, may kindly turn to page 138. That will give the brief of the case, Lordship. Page 138.
138.
Evidence of PW 18.
Yes.
Lordship, may kindly note the name that Dr. Partha P.D. Sharma. That is the name I'm pointing out because he is not a charge sheeted witness. In spite of that, we have allowed him to depose before the court because he claimed himself to be the FSL expert who examined the voice sample. And now,
To
Lordship, may
examine the voice.
voice sample of the accused.
Okay.
And that now, Lordship, may kindly turn to page 140, cross part.
Yes.
Lordship will, may I read that, Lordship, cross part only?
Yes.
It is pertinently true.
What is your name?
Lordship,
What is your name?
my name is Ahmaduddin.
Ahmaduddin.
Ahmaduddin Tapadar.
Okay. Yes.
It is partially true that quality of recorded voice sample impacts the accuracy of the analysis. I have no knowledge of the voice of Ahmaduddin Tapadar, but in my report, I have mentioned that the voice recording that I examined was of the same person which police named as Ahmaduddin Tapadar. A mimicry artist can copy another person's voice, but it can be detected only when it is compared with the original admitted voice. It is not a fact that the report which I submitted is not genuine, as there is no mention of its accuracy rate in the report. It is not a fact. Now, this is important, Lordship. It is not a fact that my report is not reliable, as I did not submit the energy levelogram diagram of my test because I submitted the original copy of the same to SP Karimganj.
What is this energy levelogram diagram?
This is like, Lordship, that X-ray of our body, that is like that, Lordship, that comparison chart, that is the energy levelogram diagram.
Okay. No.
It
what-
is true that the copy of energy levelogram diagram is not shown to me in the court. So my entire case and cross-examination was to the effect that the energy levelogram diagram was not submitted before the court. He says that it is in the custody of the SP. Now, Lordship may kindly see the additional affidavit which I have submitted. That additional affidavit is filed today. And in fact, if the same thing, your Lordship will find evidence of PW 16. So Lordship may kindly turn to PW 16 first,
Page number?
page 128. He was the one of the investigating officer and he submitted charge sheet. Page 128.
No, what you are impugning in this case?
My entire case is that, Lordship, that prosecution subsequently filed an application, not prosecution, Lordship, the learned PP who himself was the petitioner. He filed an application along with a energy levelogram diagram and said this may be admitted as evidence. So my entire case is that when investigating officer while submitting charge sheet, he said there was only 3 pages of report that your Lordship will find PW 16. He is the person who filed charge sheet. And subsequently, that report also submitted to the court. That report I have enclosed, but inadvertently we missed that that part of report in our petition. So I have filed the additional affidavit to bring on record. That finds support from the evidence of PW 16, who says that report was of 3 pages. That was confirmed through the PW 16. That part, your Lordship may kindly see page 29.
129.
Page 29 or 129, sorry, 129. Serial number 7 of exam, serial number 7. FSL report is in 3 pages given by Dr. Partha P.D. Sharma. Now that 3 pages your Lordship will see in my additional affidavit, page 155.
Yes.
This is the report, page 1, 2, 3. Along with that Lordship report, that 3 pages report, which starts from 156. This is, there is no diagram or energy levelogram diagram. And subsequently, and even in fact that PW 18 also says that it was sent to the SP. If it was sent to the SP, then it has to be submitted by the SP before the court or by the investigating officer by way of a supplementary case charge sheet, Lordship. They cannot file it in that manner. Lordship may kindly see their application now, page 145.
At what stage the trial is pending?
Evidence of 18 witnesses recorded.
How many witnesses are there?
In the charge sheet, they have mentioned 20 witnesses.
20?
20 witnesses. That charge sheet I have also enclosed, that starts from page 19 and relevant portion of that witnesses here, Lordship will find page 26. And the petition, Lordship may kindly see at page 145. They have filed the application under section 293 and 294 CRPC. They have the application has to be filed under section 311 for calling the witness, Lordship. It cannot be filed under section 293. Then when there is disputed document, Lordship. Or by the
Where is the application?
that page 145. Your Lordship. Page 145. Top portion, your Lordship will find petitioner additional PP Sribhumi. If he files that application, how I can cross-examine the PP about the custodian of that document, Lordship? I cannot cross-examine him. So it has to be submitted by investigating officer or by the SP so that I can file an application before the court that I need to examine that person for proper to determine the custody of that document. But if the
No,
PP is,
merely filing of the document is not admission of the document as evidence.
it's admitted in evidence by the court, that is the impugn order in the present case, Lord.
Where is that?
That your impugn order, your lordship will find page 150.
150.
Yes. Huh? No, no, it is not.
Yes, where?
Last part, your lordship will find, last paragraph of 150. I have considered the rival submissions as well as material on record. It is found that prosecution has valid point. Hence, in levelogram diagram, by 1488 is admitted. Prosecution shall be at liberty to recall PW18.
Recall PW18 for the,
Yes, for proving his signature only. But that custody part, that how this diagram came into existence, why it was not
somebody
submitted.
has to exhibit that.
Yes,
document.
that is my case, lordship.
What this admitted means?
Admitted means it is admitted to evidence, lordship.
No,
No, they have filed the application under section 293, and 293 says if any document is submitted by any expert, that may be admitted in evidence.
yes.
The record has to be told, Malad, otherwise, PP directly, but because, that, PW18, he stated that it was submitted
No,
before the
instead of,
SP.
where, what is 293?
Yes, 293, lordship may kindly see. Report of certain government scientific experts.
Without the examination of the expert, it may be admitted.
It may be admitted, but the condition precedent is that the sample or that thing has to be sent to him. Here in this case, your lordship, already I have pointed out, he is not a charge sheeted witness. These documents were not sent to him. In the charge sheet, it is one Kamal Datta. In the charge sheet, it was mentioned that he is the FSL expert. So it was not sent to him. The section itself says that the thing has to be sent to him. He is not the person to whom the investigating officer sent the samples. He sent to Kamal Datta, and Kamal Datta entrusted it to him. So this document cannot be admitted into evidence in terms of section 293, lordship.
FSL, he is a deputy director.
If necessary, the document which was admitted, the person who issued that document may be called for cross-examination.
No, my entire case is that the prosecution filed the application after 3 years of trial. Now I have to cross-examine the person regarding the custody of that document. Now he has been called to only prove his signature part.
You can put questions to him also.
No, he cannot. Lordship may kindly see their application also. That application says that he may be recalled only for the purpose of proving his signature. That page 145.
Then you may pray for examining the SP with in
No,
whose.
I cannot file an application to examine SP because they have to. It is their case. They have to prove the custody. But what I am
You can take this plea in your submissions, in your argument, if they are not.
No, here, lordship, this document is admitted in terms of section 293. Their application is under section 293. It will be
293
treated as
empowers.
evidence.
293,
Yes.
where is the bar? It may be admitted if it is
Once
an
it is admitted, then it will be treated as evidence, lordship. That is the difficulty.
But 293 says that if
Yes.
any report is under the hand of a government scientific expert,
Yes.
this may be used as an evidence.
Yes, may be used as evidence in a particular inquiry or trial under that. So it is already admitted. Admitted.
So
means
there is
something-
no illegality. Because 293 says where the trial court heard.
No, here, lordship, I am reading 293, lordship.
Yes.
any document purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or thing duly submitted to him. So Lordship may kindly note this part. Duly submitted to him. And if I take your Lordship to the charge sheet, he is not the person to whom this thing was submitted. It was Kamal Datta. So if anything is there, then Kamal Datta has to come to the court and he has to say these things. A person who is not a charge sheeted witness to whom the thing samples were not sent, how he can submit a report to the court, Lordship? In the charge sheet, Lordship, may kindly see page 28. I'm sorry, Lordship, page 26.
Yes.
Page 26, serial number 18. Kamal Datta, Senior Scientific Assistant, Cyber Forensic Division, Director of Forensic Science, Kahilipara. Here, all the names are mentioned. There is no mention about this, Lordship, Partha P.D. Sharma, Dr. Partha P.D. Sharma. He is not a charge-sheeted witness. So that documents were not submitted to him. So in terms of that also, these documents cannot be admitted into evidence under section 293 of CRPC. And most importantly, also that petition filed by the learned PP Lordship at page 45.
Submitted to him for examination. Suppose a sample is sent for examination to forensic laboratory.
Lordship.
The person who examined that sample, if regarding that examination he submit a report, to that report 293 is applicable.
Yes, 293 is applicable, Lordship, and in that case, Lordship, that if the report is submitted to the investigating officer before filing of charge sheet, he has to mention in his charge sheet. And if he files after charge sheet as a further investigation, in that case also, Lordship, that report has to be submitted in terms of section 173. Lordship, may kindly see section 173 CRPC, which says any supplementary material is found, Lordship, after charge sheet, then it has to be submitted in terms of section 173, Lordship, in way of charge sheet, Lordship.
Okay, so that procedure was not
Not followed.
Neither it is admitted under 311.
Yes, Lordship. Nor it was submitted as a supplementary
Okay,
charge sheet.
now what do you want?
My case is that, Lordship, I am not paying for stay because I have already suffered for 3 years. I am only paying for deferring the Lordship examination of PW18 till disposal of the case, Lordship. Other witness, they may examine. I have no objection to that, Lordship.
Yes.
Well, he being the deputy director of the forensic, he joint director. He has examined, but regarding that, he has cross-stated that it was because of it was submitted to the original copy to the SP Karimganj.
Where is the impure order?
Impure order, Lordship, at page
150.
150. Okay, heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar,
155.
learned additional public prosecutor. This application under section 528 of DNSS, read with article 227 of the Constitution of India, has been filed by the petitioner, namely Ahmad Uddin Tapadar alias Imad Uddin Tapadar, impugning the order dated 12/8/2025 passed by learned Special Judge Sri Bhumi in Special NDPS case number 155/2022, whereby the application filed by the learned public prosecutor under section 293/294 of CRPC for bringing on record the FSL report submitted by Dr. Partha P.D. Sharma, wherein the wherein the documents regarding levelogram diagram of the voice test of the voice sample of the petitioner conducted by the FSL forensic laboratory was admitted. Stop. Learned counsel for the petitioner has submitted that the said witness, that is PW 18, Dr. Partho P.D. Sharma, was not a listed witness, was not an enlisted witness in the charge sheet. And the document in question, which document is admitted?
That energy levelogram diagram, Lordship.
Where is that energy levelogram diagram?
That was submitted to the court, Lordship. Okay, along with that application, Lordship, that copy is not with me, Lordship, that annex.
Whereby energy levelogram, energy
levelogram diagram.
energy levelogram diagram in respect of the voice tests conducted on the sample voice of the petitioner by the forensic laboratory was never submitted along with the documents. A line to production. Starting. This line, the document. Was not submitted along with the report, along with the charge sheet. And therefore, learned counsel for the petitioner submits that unless the said report is submitted along with the charge sheet filed under section 173 of the Code of Criminal Procedure, or in pursuant to any further investigation directed and thereafter the said material is submitted under Article sections 173(8) of the CRPC, same cannot be taken into consideration. He submits that other option available for the other option which could have been availed was by exercising the powers of the court under section 311 of the CRPC, which also has not been done in this case, as the stop. He therefore submits that the said levelogram diagram cannot be admitted in the trial pending against the petitioner, cannot be admitted under section 293 of CRPC in the trial pending against the petitioner. He further submits that the PW 18 has been recalled as recalling prayer is allowed.
Page 150, last line. Prosecution shall be at liberty to recall PW 18.
but whether that liberty has been exercised.
Yes, it was already exercised on last occasion. We filed that we have application indicating that we have filed criminal petition, which is likely to be.
Recall PW 18. Stop. No, where is the mention that he was recalled only for the purpose of exhibiting the signatures?
That your lordship will find in their application itself.
He further submits that prayer for recalling of the PW 18 has been made only for the purpose of exhibiting the signatures of the PW 18 in energy levelogram diagrams, which if done would deprive the petitioner from putting the energy levelogram diagram under cross-examination. Stop. Learned additional public records would be necessary.
Public records will be necessary because my entire case is that from the date of filing of the charge sheet.
Okay.
Till also.
Learned additional public prosecutor, on the other hand, submits that the trial court records along with the concerned case diary may be called for. Stop. Let the scan copy of the trial court records along with the connected case diary be called for. Let this case be listed on 27th of October. In the meanwhile, as the contentions raised by the petitioner deserves consideration, the
Re-examination of PW 18.
The re-examination of PW 18 shall be put to a halt till the pendency of this criminal petition. However, it is made clear that the trial court may proceed with examination of other witnesses in its normal course, list accordingly.
How like?
Binding item 6 for withdrawal.
The.
Heard.
One to which. yeah.
Heard Mr. N.K. Kalita, learned counsel for the petitioner. Both live
Yes, ma'am.
who prays for allowing the petitioner to withdraw the leave application in respect of the criminal appeal filed by him. The prayer is allowed. The leave application filed by the petitioner being criminal LP 35/2025 is hereby dismissed on withdrawal.
Public.
Item 37.
Applicable. This is before lottery, my lord. Now, if I was lost by the Bureau of Economic Offences, my lord, and way back in 2000, it was lost on 2014, my lord, regarding forest royalty, non-payment of forest royalty.
Non-payment of forest royalty.
Yes, it is page 25 is the FIR, my lord. It was lost by one Aditya Kumar Khan, the deputy conservator of forest, my lord, BIO Assam. And that it was stated that regarding construction of during the preliminary inquiry number 6 of 18, dated 28/2003, was initiated by against the deputy chief engineer, construction Lamding railway station, and contact respect of utilization of forest produce in a gross conversion from Lamding to Silchar. During the course of inquiry from March 2003 till date, reveals that 11 number of CAs has been paid their bill amount to the contractors found by deputy chief engineer contract 2 without realizing the forest royalty, VAT, etc. In the deputy chief engineer and his contractors found to have violated section 32, 33, 34, 41 of the Assam Forest Rules amended and evaded the forest royalty and VAT found to be rupees 4 crores 29 lakhs 43,000 so and so. They misreported a huge amount of money which is due to the state government, and contractors with some officials of Lamding railway station entered into criminal conspiracy, resulting loss to the government of Assam. Forest produced.
Now, what is your prayer?
Now coming to it, my lord. What has happened, my lord? Charge sheet was submitted. In the charge sheet, my lord, I was initially charge sheet, my lord, I was not named in the charge sheet, my lord. Subsequently, a supplementary charge sheet was filed, my lord. That you will also find at page 62, my lord. Page 62, my lord. That the supplementary charge sheet that you will also find, I therefore submitted charge sheet number so and so 331/10/2020 as additional charge sheet number so and so against the accused Ajay Pradhan, and that's the petitioner, my lord. Here it says that I pray before your honor to take cognizance against the accused so and so. It is as it more than 4 months since the prayer for obtaining prosecution sanction was submitted to the competent authority, but no reply has been received. In the case, prayer for recording prosecution sanction was submitted to the general manager NF Railway on 1/2/2025, letter number so and so, dated 19/3/2020. In view of the judgment of the matter of Dr. Subramanian Swamy versus Dr. Manmohan Singh and other in civil appeal number so and so, since no decision was taken by the authority, sanction is directed to have been granted to the proposed prosecution, and on the charge sheet has been submitted against the petitioner. On the basis of investigation were conducted, I have sending the accused to face trial. So they did not obtain the sanction immediately. Now they have interpreted the decision of the Dr. Subramanian Swamy and Manmohan Singh, my lord. That decision, my lord, I mean, close that you will also find at page. That is page 73, my lord, and lecture 5. The relevant portion of the judgment, my lord. Conclusion part, my lord. What has happened? There is another case, there is Vinit Narayan case, my lord. That of Supreme Court where some principles of has been laid down. And that has to be complied with, that has been stated, your lordship, my lord. That relevant portion, your lordship may kindly come. The paragraph 1, page 113, para 48, my lord. 48. Then next page 114, my lord, grant of sanction. Grant of sanction is the administrative, that is a justice. There are two judgments, my lord, two separate judgments were passed by the court, my lord. And supplementary judgment, my lord, that you will also find. There he says that grant of sanction is the administrative act, the purpose of to protect the public servant for husband so and so. Question of giving on that. There no timeline has been given in this. They have that. Aforesaid guidelines is confirmed. That guidelines at 1, 2, 3, and 4, my lord. That
Where are you reading?
That page 114, my lord.
114. Yes.
That the grant of sanction is administrative. The purpose is to protect the public servant for harassment. The question of giving opportunity for at this stage doesn't arise. Competent authority cannot embark on inquiry to the judge the truth so and so, and offer his comments to the further investigative matter. However, if any case of sanctionary after considering the entire material, before it entertains any doubt, any point of competent may specify the doubt with sufficient particulars, may request the authority who has sought sanction to clear the doubt. But that would be no clear the doubt in order to authority to apply his mind so and so. If the sanctioner seeks to comments from the IO while the matter is pending, so adverse to the impossible sanction to adhere to the time limit allowed by the Supreme Court so and so. So these are the guidelines that is now in the supplementary. Justice Ganguly, my lord, A.K. Ganguly, my lord, while supplementing the charge sheet, my lord, what he had stated, my lord, that you will also find that paragraph regarding time limit, my lord, that you will also find at page 1, 2, 3, my lord, of the running page, my lord.
Yes.
There paragraph 80, my lord. The paragraph 79 onwards, my lord. Article 14 must be constituted as a guarantee against the uncanalized and arbitrary power. Therefore, absence of any time limit in granting sanction under 19, that is 19 of the PC Act, my lord. Because Subramanian Swamy case is relating to 19, my lord. He filed against into this case against the Prime Minister, my lord. Is not a consonance with the requirement of due process of law, which has been read into our constitution by the constitutional bench of the court in Maneka Gandhi's case. I may not understand, may not be understood to express that any doubt about the constitutional validity of Section 19. But in my judgment, the power of Section 19 must be reasonably exercised. In my judgment, Parliament, your lordship may kindly see, Parliament and appropriate authority may consider restructuring of Section 19 of the PC Act in such a manner to make it consonant with the reason and justice and fair play. In my view, Parliament should reconsider constitutional imperative Article 14 ensuring the rule of law to a due process of law read into introduction of time limit in section 19 in working of a reasonable manner, in my opinion, consider the following guidelines. All proposal of sanction must be placed before a sanctioning authority to grant of sanction of public servant under section 19 must be decided within a period of 3 months of the receipt of the proposal of the authority. When a consultation is required by the Attorney General or Solicitor General or Advocate General, as the case may be, same is not possible within 3 months. An extension of 1 month may be allowed, but request for consultation will be sent in a writing within 3 months mentioned above. A copy of this request will be sent to the prosecuting agency or the private complainant to intimate them about the extension. At the end of the extended period, if no decision is taken, it will deemed to have been granted by the proposal of the prosecution, and the prosecuting agency and private complainant will proceed to file the charge sheet within the commencing within the 15 days. So that was the, so they paid for, decision was to amend the section 19. And accordingly, section 19 has been amended, Your Lordship, in 2000 of the PC Act.
Convention of corruption.
It was amended in 2018, my lord. So far PC Act is concerned, my lord. There says, my lord,
Yes.
so the time limit of 3 months has been given, my lord. That Your Lordship, by proviso, there was a proviso, my lord. There says a third proviso, my lord, provided Your Lordship may kindly come. Second proviso. Second proviso starts, my lord, provided in case of request for person other than that can be skipped over, my lord. Provided also third proviso, appropriate government or competent official after receipt of proposals, sanction of prosecutions, and you are to convey decision such proposal within a period of 3 months from date of receipt. Provided in case for purpose of grant sanction, the so required. So 3 months was that has been inserted, my lord. But 197 has not been amended, my lord. 197 has been amended only in BNSS, my lord. That is has come into effect in 2023, my lord, where deeming provision has been laid off. But in PC Act, deeming provision was not there, my lord.
Now, suppose it is not submitted within, sanction is not obtained within 3 months.
Yes, sir.
What would be the consequence?
That now because of BNSS, that amendment has come.
What would happen in earlier cases?
It says section 218, my lord, of BNSS, my lord. It says that,
No, but by virtue of that judgment,
but judgment doesn't say so far as IPC offense is concerned. It's pertaining to basically regarding
PC.
PCA. Your Lordship. And a suitable amendment has to be made that was not amended at that point of time. So Justice Ganguly has stated that it is not consonant with Article 14. So there will be misuse of power by the authorities by withholding the sanction. So necessary direction, so amendment should be made. And accordingly, suitable amendment made in the PCA. So far as the IPC offences are concerned, this amendment has come into effect in 2023 by BNSS, where your Lordship will find that the says a second proviso, such government shall take a decision within a period of 120 days from date of request for the sanction. In case it failed to do so, sanction will deem to have been accorded by such government. That is
section 197.
218, my 197, no amendment was there. Only in BNSS it has come.
218.
So my perhaps. So based on the prosecution, so deemed provision will not come into effect, my lord, so far the present petition is concerned. Because that was prior to amendment. That is my case, man. They are relying upon a judgment. That judgment is relating to PC Act, man, where PCB was subsequently was amended. But so far IPC offences are concerned, it has come to effect in only 2023.
In PC Act, there is no deeming provision.
No deeming provision, but time limit was there, man. But whatever it is, but they are relying on that judgment. They want to say that it will be deemed to be a sanction has deemed to have been given effect. My humble submission, that contention of the prosecution, my lord, that if IO, it cannot be taken into consideration. So, by cognizance order, my lord.
No, in page 114.
Yes, my lord.
Of the judgment.
114
of the petition.
114, grant of section, my lord.
Grant of section.
That is, they have to, yes, my lord. Yes, this is regarding the,
There is no deeming provision,
there is no living provision.
only in Justice Ganguly's.
Justice Ganguly, that has been incorporated, madam. But however, in the PC Act, that was not taken into consideration, only 3 months the period was given and 1 month. Only in IPC, my lord, subsequently in 2003, my lord, BNSS, that this living condition clause has come to effect, my lord.
Okay.
So my in this case, my lord, order of cognizance is illegal, my lord, without, since admittedly, that is on page 72, my lord. That,
No, but cognizance was taken last year,
no, 24.
24.
Because I'm not appeared, my lord. Today we have someone who is on 17, I've received the summons. 17th of September, my. 73, because your lordship, 19th, IO has submitted single charge sheet. I've gone through the case record, original charge sheet. I would have finding sufficient incriminating materials, so and so. Accordingly, I have taken cognizance against accused Ajay Pradhan, so the accused someone against it. Ultimately, in the month of September, I have received the sum. So this order of cognizance is bad in law because, in fact, there is no direction in the judgment, my lord. As I've already pointed out, my lord, that time limit is there, my lord. Only subsequently, due to amendment of the new CRPC, my lord, that time limit has come, my lord, and deeming clause has come into effect. That is prospective.
Okay. Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Ajay Pradhan, impugning the order dated 19/11/2024 passed by the learned additional Chief Judicial Magistrate Kamrup Metro in PRC case number 486/2020, whereby cognizance of offense under section 120B/409/379/411 of IPC, read with section 32/33/34/40/41/49 of the Assam Forest Rules was taken against the present petitioner. Learned counsel for the petitioner has submitted that the aforesaid PRC case was registered on filing of an FIR by one Aditya Kumar Khaun, DCF, BIEO Assam, before the officer in charge of BIEOP police station, inter alia, alleging that on the basis of a preliminary inquiry which was initiated against the present petitioner, it was found that the present petitioner and his contractors / firms have violated the aforesaid provisions of Assam Forest Rules and evaded forest royalty and VAT to the tune of rupees 4,29,43,407.67. Stop. Learned counsel for the petitioner has submitted that in the original charge sheet, after completion of the investigation, the charge sheet was filed. And in the original charge sheet, the petitioner was not named as an accused. However, in the supplementary charge sheet, the petitioner was arrayed as an accused. He further submits that though the petitioner was posted as
Deputy, at
deputy,
the relevant time, my lord, he was deputy chief engineer,
posted as deputy
chief engineer,
chief engineer
construction.
construction under North
NF Railway Landing Division.
Anaf Railway Lamding Division. However, no prosecution sanction was obtained. He further submits that the investigating officer has wrongly interpreted the judgment of the apex court in the case of Dr. Subramaniam Swamy versus Dr. Manmohan Singh reported in 2008 1 SCC page number
Page number, your lordship. Relevant page, last page, my lord, that is,
no, the citations page
or citation, 2012 3 SSC, page 64, my lord.
2012 3 SCC page 64. Inasmuch as it interpreted the said judgment to for deeming that if the prosecution sanction is not granted within 3 months of the date of seeking it, it shall be deemed to have been granted. Stop. Learned counsel for the petitioner has submitted that in the aforesaid judgment, the apex court had only observed that the parliament should consider to introduce necessary amendment in section 19 of the PC Act with a deeming provisions. Learned counsel, 19 was amended accordingly.
An amendment was, but deeming provision was not followed. 19 was amended.
Learned counsel for the petitioner has submitted that accordingly, section 19 of the Prevention of Corruption Act was amended. However, wherein it was provided that the prosecution sanction
Within a period of 3 months, my lord.
shall have to be a decision on the prayer for granting prosecution sanction shall have to be made within a period of 3 months from the date of its receipt. However, no such deeming provision was incorporated in the PC Act. Learned counsel for the petitioner has submitted that in the instant case, the offence alleged against the petitioner are under Indian Penal Code as well as under Assam Forest Regulation. He further submits that the deeming provision for grant of sanction, deeming provision on failure of the grant of sanction within period of 3 months has been incorporated in section 2
As 218, my lord, proviso, second proviso, my lord,
in section 218
of PNA. 2020.
section 218 within bracket 1. In second proviso to section 218 within bracket 1, which provides that the government shall take the decision regarding grant of sanction within a period of 120 days from the date of receipt of sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. Learned counsel for the petitioner has submitted that the deeming provision as incorporated in the aforesaid proviso to section 218 within bracket 1 of BNSS came into force on 1st of June 2023, whereas the charge sheet in this case has been filed prior to that.
Prior to the 2000 supplementary charge sheet, my lord, that is on 2020, my lord.
Supplementary charge sheet was filed against the present petitioner
31/10/2020.
on 31/10/2020. That is much prior to the coming into force of provisions of section 218 of BNS. He therefore submits that in the instant case, the order of taking cognizance against the present petitioner is bad in law, inasmuch as no prosecution sanction was there for taking such cognizance against the present petitioner. So the contentions raised by the petitioner deserves consideration, and hence let the scanned copy of the trial court records as well as scanned copy of the connected case diary be called for from the trial court. Let this matter be listed on 28th of November, the first part of on 6th of November. In the meanwhile, considering the fact that on perusal of the materials available on record, it appears that there was no prosecution sanction for initiation of criminal proceedings against the present petitioner when the charge sheet has been filed, and the deeming provision contained in section 218 of the BNSS came into force only on 1st of July 2023. That is much after the date of filing of the charge sheet. Date of filing of the supplementary charge sheet against the present petition. Hence, till next returnable date, further proceeding of PRC case number 486/2020 shall remain stayed.
But one thing is that the sanctioning authority is the railway, otherwise not done or done, perhaps the railway also maybe made a party. So,
Let the report come.
and
28.
My lord, case number 20, my lord, NBWA has been issued against the petitioner because my lord, the petitioner could not appear before the trial court due to the illness. His wife is suffering from pregnancy, my lord, that was the date of delivery. So I have annexed the medical documents also. Case number 20. My lord, the next date the petitioner is ready to appear. He will not fail, my lord.
When is the next date?
Next date is, my lord, 3rd of November, my lord. Positively, he will appear, my lord.
Heard Mr. A Ali, learned counsel for the petitioner. This application under section 528 of BNSS, read with article 227 of the Constitution of India, has been filed by the petitioner, namely Jibon Gogoi, impugning the order dated 29/7/2025 and subsequent order passed in NDPS case number 8/2025, whereby non-bailable warrant of arrest were issued against the petitioner. The petitioner has submitted that the charge sheet has been laid in the aforesaid case against the petitioner under section 20B2B/29 of the NDPS Act. And on the fixed date, the petitioner could not appear before the trial court as he had to remain busy in assisting his ailing wife, who is carrying an advanced stage of pregnancy. Learned counsel for the petitioner submits that the next date in the NDPS case number 8/2025 is fixed on 3/11/2025. And the petitioner is ready and willing to appear before the court on that date and cooperate in the trial. However, he seeks some protection as pending NBWA warrant, pending non-bailable warrant of arrest is there has been issued against the present petitioner. Stop. I have considered the submissions made by learned counsel for both sides. Considering the reasons shown by the petitioner in defaulting to appear before the trial court on the fixed date, as well as his willingness to appear before the trial court on the next fixed date, this court is inclined to grant interim protection to the petitioner. Accordingly, this criminal petition is disposed of with a direction to the petitioner to appear before the trial court, that is the Court of Learned Sessions Judge Dhemaji, in NDPS case number 8/2025 on the next date fixed before the said court, that is 3/11/2025, and cooperate in trial. To facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him by the trial court shall remain suspended till that date. So on his appearance before the trial court, the petitioner may seek any relief before the said court to which he is legally entitled to. This criminal petition is accordingly disposed.
Item 31.
May I please your lordship, the engaged counsel is weak on other board. Please take the matter after some time.
Item 32.
Wait, please, your lordship. Sir, see, in this case, we have
file quashing of the complaint can instituted under section 27D of the Drugs and Cosmetics Act, as well as the order dated 11/6/24, wherever cognizance has been taken against the petitioners. Your Lordship, prior to taking your Lordship to the complaint case, may I just place section 34 of the Drugs and Cosmetics Act?
Yes, what it says.
Section 34, offenses by companies. Where an offense under this act has been
34,
committed by a company,
34.
every person who at the time the offense was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Provided that nothing contained in this subsection shall render any such person liable to any punishment provided in this act if he proves that the offense was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offense. Notwithstanding anything contained in subsection 1, where an offense under this act has been committed by a company and it is proved that the offense has been committed with the consent of or connivance of or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, such director, manager, secretary, or other officer shall also be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Here, let's say what I say is that prior to making the directors a party in the complaint, there has to be an investigation as to whether they have they had knowledge about the commission of that offense, or there is that any drugs which is manufactured by them, there is some substance in that. Now, your Lordship may kindly see the complaint, which starts at page number 168. And the only allegation against the directors in this case can be found at para 14 here. Para 14 is at page number 174.
Yes.
Once para 14, that the complainant begs to state that from the positions and facts stated above, it is quite clear that the accused number 1 manufacturer and accused number 2 to 5 directors were responsible in the manufacture for sale and distribution of not of standard quality drugs, which is an offense committed under section 16(1)(a), 18(a)(1) of the said act and punishable under section 27(d) of the said act. Except for this averment, your Lordship, the complaint petition is completely silent as to why the directors have been made a party in this complaint. There has to be an investigation being carried out. And this position is being cleared by the Honorable Supreme Court in a recent judgment of 2025, your Lordship.
Yes.
Your Lordship, may I just please paragraph 12 of that judgment, your Lordship. At page number 7.
Yes.
It is in the state background and asserting that there is no material whatsoever on record for the complaint regarding the role of the appellant in commission of alleged offense and for the day-to-day affairs of the company. The appellant herein approached the High Court of Bombay for assailing the summoning order dated so-and-so, passed by so-and-so, by preferring the subject petition under section 482 CRPC, which stands rejected by the order dated so-and-so, which is under challenge in this appeal by special leave. Now, your Lordship may kindly have a look at paragraph 21.
We'll continue at 2.
Item number 1.
For reasons mentioned in the judgment, the revision petition is allowed to the extent that the petitioners are allowed to be released on furnishing bond of rupees 30,000 each for maintaining peace and good behavior for next 1 year from the date of this order under section 4 of the Probation of Offenders Act 1950.
Item 2. Item number 3.
For reasons mentioned in the judgment, the criminal petition is allowed and CR case number 185/2013 instituted by respondent is hereby quashed.
Item 3 and 4.
3 and 4, I need some more time. Some queries are there. I am fixing it on 17th of October. Take dictation, Lily. Certain, though this case was fixed for delivery of judgment, however, certain clarifications are required. And therefore, let this matter be listed on 17th of October for hearing. Keep it as part heard.
Item 5.
For reasons mentioned in the judgment, this court is of considered opinion that this revision petition lacks merit and accordingly does not justify any interference by this court with the impugned order. Same is accordingly dismissed.
May it please your lordship, lordship, item number 47, lordship. There's some urgency, lordship. Lordship, this matter, lordship, please to take the after motion, lordship. Yes,
What is the urgency?
lordship, the urgency, lordship, this criminal appeal, lordship, appeal against conviction, and this IA for allow the petitioner go on the previous bail, and the learned trial could allow the appellant to go on the previous bail.
But such urgency is there in every case.
Lordship, that is on 26/9/25. Lordship, till 26/9/2025.
We'll see whether we can take it up or not. Yes. Let us see.
May it please. Lordship, I was placing the judgment of the Honorable Supreme Court.
Yes.
Yeah, Lordship, may kindly see paragraph 22, page number 40.
No, your crux of your submission is that directors cannot be made
Yes, Lordship, without there being specific averment.
in
with
the
regard to-
complaint petition.
Yes,
And in
Lord.
this case, there is no specific averment.
Lord.
That is the crux. Yes, Mr. Decker. Sorry.
By virtue of his designation, he has to be responsible for the company's affairs.
Now, in this case, there is no managing director. Because whenever a particular complaint is filed under Drugs and Cosmetics Act.
Yes. What is the accusation that they manufactured substandard drugs? That is,
So will go by the report that it is mentioned as not of standard quality.
not of standard quality.
That is report that has been comes out from Regional Drug Testing Laboratory, RDTL.
Okay.
And secondly, my lord, whenever the RDTL submitted its report stating that a particular drug is not of standard quality, then the notice is issued under section 18A of the Drugs and Cosmetics, under the Drugs and Cosmetics Act, my lord, to the manufacturer and other person. Now thereafter, my lord, it is a duty to whom such kind of notice has been issued, we should provide the detailed information. And before filing of the complaint, my lord, apart from issuing the notice under section 18A, we also check the record under register of combination, who is the managing director of a particular company. But here, the no such person has been found under the designation of managing director. So, my lord, vicariously, then, my lord, every director of that particular company become vicariously liable. That is my thought.
For the offense also.
Yes.
But the apex court's judgment,
I apologize to this honorable court, I have not gone through this judgment. But my lord, the Drugs and Cosmetics Act is a beneficial legislation.
now what was the offense involved in this case, this apex court?
Lordship,
What was the offense involved?
there is a paragraph 12.
What was the offense? Under what?
Here also, your lordship, there was an allegation that substantial drugs were manufactured.
Under what provision the offense was alleged?
27.
In the cited case also?
Yes, sir. 27. Paragraph 4, your lordship.
At what stage the case is pending?
It's for appearance, your lordship.
And you are for accused number?
I'm 2 to 5. Company has also made a party in the, that is petitioner number 1.
Who will represent the company?
Your lordship, as such, in the complaint, they have not stated anyone, but there will be one authorized representative who will represent.
Heard, Mr.
H.
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 A. Setia, learned counsel for the petitioner. Also heard Mr. B. Deka, learned central government counsel, appearing for the respondent number. Sole respondent. Sole respondent. Learned. This application under section 528 of BNSS has been filed by the petitioners, Messrs. Reliance Formulation Private Limited and
There are 5.
5 others, 4 others, impugning the order dated 11/6/2024 passed by the Court of London, Judicial Magistrate First Class, Kamrup Metro, Guwahati in CR case number 391/2024, whereby the cognizance of offense under section 27D of the Drugs and Cosmetic Act 1940 was taken by the said court and processes were issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner number 2 to 5 are the directors of the company arrayed as petitioner who
Accused number 225.
who petitioner number 2 to 5 are the directors of the company, that is petitioner number 1, and they are arrayed as accused number
225.
2 to 5 in the complaint filed by the respondent, that is Union of India, through the Drug Inspector, Office of the Assistant Drug Controller, Central Drug Standard Control Organization, Subzone Guwahati, under section 27.
D.
27,
D, small d.
small d of the aforesaid act. Learned counsel for the petitioner has submitted that the only accusation made in the, no accusation has been made against the present petitioner. Present petitioners in the complaint filed by the respondent. Complaint filed by the respondent. He submits that the trial court has erroneously taken cognizance of the offense in contravention of the provision contained in proviso to section 34 of the Drugs and Cosmetic Act 1940, as there is no averment made in the complaint petition that the offense alleged was committed with the knowledge of the present petitioners, who are the directors of the company. Learned counsel for the petitioner has submitted that the Apex Court very recently in the case of Shail Shalmanu Singh versus State of Maharashtra, arising out of within bracket order dated 22 July 2025 in SLP criminal number 5618/2023 has observed that which para? Which para? you are-
22.
Has observed that has observed as follows. Quote para 22 from the said judgment. Judgment is in the record. Learned counsel for the petitioner has submitted that in the instant case, no prima facie accusation has been leveled in the complaint, which would have satisfied the trial court regarding the consent, connivance or attributable neglect on the part of the director who is sought to be prosecuted by taking recourse to the concept of vicarious liability as provided under section 34 within bracket 2 of the Drugs and Cosmetic Act. Act 1940, stop. On the other hand, learned Central Government Standing Council has submitted that the managing director of a company is normally answerable for the affairs of the company. However, in the instant case, no name of the managing director could be found. Neither same was disclosed to the complainant when notice under section 18A of the Drugs and Cosmetic Act was issued. He submits that under such circumstances, as the acquisition in this case is of manufacturing drugs which are not found up to the standard, the directors, the petitioners who are the directors of the company would be vicariously liable. Stop. I have considered the submissions made by any records would be necessary.
So let's say I have already annexed the certified copy of the entire.
No, you will be filing any objection? No. We'll issue notice. Okay. Issue notice. Since Learned Standing Council, Central Government, Learned Central Government Standing Council has already appeared, no formal notice need to be issued. However, as he has submitted that he has been handed over the brief only yesterday, some time is granted to see to the Learned Standing Council to seek necessary instructions in this regard. Let this case be listed after 4 weeks. In the meanwhile, as prima facie it appears that no accusation has been made in the complaint petition which would have satisfied the trial court regarding the consent, connivance or attributable neglect on the part of the present petitioners who are the directors of petitioner number 1. Further proceedings of complaint case bearing number CR case number 391/2024 pending before the Court of Learned Judicial Magistrate First Class, Kamrup Metro shall remain stayed till next returnable date. Till next date.
Highly.
Where is the petitioner?
Item number 9.
Okay, we'll take it up after some time, or should. IO is not. Oh. Now, what is your submission? 2 days it will, he is behind the bars. Okay, let the council come. We'll call it after some time.
31.
May I please, Your Lordship?
Yes.
I'm sorry, when I couldn't be there when matters called matter, I did. But, this is under 528 BNSS matter, for quashing, my lord. My lord, what has happened here, my lord? The petitioner, my lord, he passed his HSLC examination in 2010. Earlier, he had attempted in 2001, he failed, my lord. And he passed his HSLC examination in 2010. In the meanwhile, he had already joined service. Now, after almost in the year 2024, page 33, the FIR was lodged, alleging that the petitioner had taken his the complainants the registration number and sat in the examination in 2010. May I read that, my lord? Page 33, Annexure 6. Most respectfully, it is stated that I was studying at Namargaon High School. I filled a form in 2004 for registration in class 9, but did not receive the registration card. As a result, I went to the Namargaon High School seeking the said registration card for appearing in HSS examination 2006. But I could not sit in the HSS examination, and the headmaster informed me that my registration card has not arrived. But now I could learn that by virtue of forgery, the below mentioned accused person, that is the Chokidar of the Kukurmara Higher Secondary School, appeared in 2008 HSLC examination by using my registration certificate of class 9 but failed. Thereafter, again in 2010, the accused passed the HSLC examination as private student using my registration number so and so. By virtue of the said forgery, the accused has been working as Chokidar of the Kukurmara HS School and also enjoying the benefits of salary and other facilities, and he ruined my life uncompensated. Now, on the basis of this FIR, my lord, the charge sheet has been submitted. My lord, I passed my matriculation exam in 2010, my lord, and I have secured my job, my lord.
What is the status of the?
Status of the charge sheet has been submitted, my lord, and the case is fixed for, my lord, consideration of charge, my lord.
You have appeared?
Yes, my lord. I have appeared, my lord. Consideration of charge, my lord. Now, my lord, what has happened here, my lord? Lordship will kindly see, my lord, the charge sheet. Charge sheet, my lord, refers to the, my lord, report by the SEBA.
What relief you are seeking?
Well, I have come for quashing of this, my lord, proceedings, my lord.
We'll examine it.
My lord, my lord. But only, my lord, Lordship will kindly look at the, my lord.
You can take this plea before the trial court also.
That, my lord, could have been taken, but here the issue is, my lord, Lordship will kindly see the, my lord, report for once, my lord. That's why, my lord, before Lordship, my lord. The SEBA report. The SEBA reports, Lordship will find page 62 and 63, my lord. Now, my lord, Lordship, if Lordship looks at the 62 report, my lord, Lordship will see they found, my lord, the so-called registration number that is, my lord, being, my lord, assigned to me, my lord. That doesn't be, that is in the name of one Awal, that is in the name of, my lord,
informant,
my lord. But, my lord, as per their record, my lord, I have passed matriculation as Awal Hussain. So far as matriculation record are concerned, I am there in the records. But the registration number is of someone Awal Hussain. And there is, he appeared in 2004. He said that he appeared for, he applied for SEBA registration in 2004. I appeared in 2010. And initially I appeared in 2001, I failed. I appeared in 2010. He wanted to appear in 2004, but 2006 on the basis of 2004 registration, but he was not given that permission to appear because it was said that his admit card has not come. Then your lordship will find the next page. But
how it is possible?
Exactly. Because
names will be there in admit card. Attendance sheet photographs will be there. So if it is forged, everything has to be forged.
And if I forge, I will not have my mark sheet in my name.
Yes.
The mark sheet has, how the mark sheet has come in my name? That is the controversy here.
You take this plea before the trial court. during framing of charges.
The registration number, the name should be recall me. Name should, our Lucien is common.
That is what I'm saying, my lord. If I had forged this, my lord, registration, let me assume for a moment I have forged this registration number, my lord, and the admit card.
Now, what is your case?
My case is, my lord, this is totally, my lord, a case of, my lord, mistaken, my lord, maybe there's some mistake somewhere, my lord. It's not a criminal, it cannot be a criminal offense, my lord. And I did not use this document anywhere because I, my lord, got my job in 1983. In 1986, my lord, and for my lord, piano which post with Chokidar, my lord, only my lord, class 8 pass is required.
Okay, let us. Heard Mr. M. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Awal Hussain, praying for quashing of the proceedings of PRC case number 38/2025. Stop. Learned counsel for the petitioner has submitted that the matter is fixed before the trial court for consideration of charges. Issue notice to the respondent number 2 and number 3 by registered post with AD as well as by usual mode within usual mode stop. The petitioner shall take steps for issuance of notice upon respondent number 2 and 3 within 7 days from the date of this order, returnable after 4 weeks. Let the scanned copy of the records of PRC case number 38/2025 along with scanned copy of the connected case diary be called for. List accordingly after.
May I pray for an interim, my lord, for
Interim, you first approach the trial court.
Right.
You can raise all pleas before
that
the,
I can.
you may get relief there itself. Other,
If I don't get, I'll renew my prayer here, my lord.
Item 43.
May it please the
after
Lordship.
4 weeks.
Lordship, I am praying for an adjournment in this matter, my lord. We want to take some instruction from our client.
Heard. Mr. What is your name?
S. Upadhyay, on behalf of
S. Upadhyay, learned counsel for the petitioner, who prays for an adjournment for seeking some instruction which is relevant to this case. The prayer is allowed. Registry to list this matter on a date to be fixed by it.
I am highly obliged.
Item 44.
Yes.
May please, your lordship. My lord, this is a criminal petition, my lord, challenging the orders of the lower courts. Lordship will come at page 24, my lord. But I filed a complaint case before the CJN Kamrum. Annexure 6, my lord. Annexure 6 is the complaint petition, my lord.
Page?
Page 24, my lord.
Yes.
This is the complaint case, my lord, which I filed before the CJN Kamrum, my lord.
What was the judgment?
My lord.
Judgment?
The impugn order is at, my lord, page 39, my lord. The CJN Kamrum, my lord, had dismissed my case
Dismiss.
Yes, my lord. Lordship will come that order at page 42, my lord. The fact is that, my lord, I took a loan for purchasing a vehicle. And after repayment of some my EMIs, my lord, due to some financial crisis, my lord, I could not pay. What they did, my lord, the bank officials, my lord, they engaged some agencies, private agencies, and they forcefully took away my vehicle from my residence, my lord. That is the case, my lord. Now, lordship, the CGM, my lord, Kamrup, my lord, they have passed a order, my lord, impugn order at page 39, which starts, my lord, page annexure 9, page 39.
What it says?
But it says that, my lord, if a lordship come to page 42,
Yes.
my lord, the second para, looking into the factual matrix of the complaint case, it appears that there is no specific allegation and involvement in the complaint petition, complaint that fraudulent and dishonest intention of the accused was there from the very beginning of the transaction between the complainant company and the accused. From the statement of the complainant and his witness, it does not appear that the accused has had any guilty mind to deliver the complainant and to commit the criminal breach of trust. It is also not. It also does not appear therefrom that there was some specific involvement as regard to the extortion or specific act showing criminal intimidation by the accused to the complainant. The bank recovery agency also never used any police help, which shows that the users of any force on their part appears to be a mere allegation only. Thereafter,
the accused were discharged.
no, my lord, notice has not been issued, my lord. Someone has not issued.
Refused to take
Yes, refused, my lord,
cognizance.
under 203, my lord.
Okay.
The same was upheld by the district session judge, my lord.
So where is the error?
Error is that, my lord, my allegation was that the bank official has used their muscle powers, which cannot be done, and recovery was made by a private agency, which also cannot be done. If they want to possess the vehicle, they have to go to proper procedure of law.
Okay, we are issuing notice. Heard Mr. SP Das, learned counsel for the petitioner. Also heard Mr. KK
But there are no party.
KK Parash. Not. Okay. This application under section 528 of BNSS has been filed by the petitioner Shri Utpal Pathak, impugning the judgment and order dated 31/5/2025 passed by the Court of Learned Additional Session Judge number 5, Kamrup Metro, in revision petition number 30/2023, whereby it upheld the judgment, upheld the order dated 13/2/2023 passed by Learned Judicial Magistrate First Class in CR case number 956/2021, whereby the complaint filed by the present petitioner was dismissed under section 203 of the Code of Criminal Procedure. Criminal procedure stop. Issue notice to the respondents. And the petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of the trial court as well as appellate court be called for registry to take step for requisitioning the aforesaid records. List according.
After 4
45.
May it pleases your lordship. In this case, my lord, I am the informant of a case. I had lost an FIR, my lord, which is ended up with a final report. Thereafter, my lord, without issuing any notice to the informant, that final report has been accepted, my lord, by the learned trial court. Now, lordship may kindly come to the order sheet which I have annexed. Lordship will find at page number 25, my lord. I have annexed the entire order sheet, my lord. There are only 3 orders. As per order dated 4/7/24.
Page number?
Page 25, lordship, 25 onwards. May I read, madam? As per order dated 4/7/24, investigating officer of the aforementioned case has investigated the case under section so and so of the IPC and submitted final report in the case. Final report is seen, issue notice to the informant, if any objection or not. Thereafter, case, it was fixed on 11/7, and as per the order dated 11/7/24, as per order dated 4/7/24, notice was sent, informant is not present, also informed through WhatsApp. It is incorrect spelling, it is recorded, my lord. Informant is not present in the court, let again a date be fixed on 27/24. Now lordship may turn to page 26. This is the impugn order, my lord, order dated 27/2024. As per order dated 11/7/24, informant is again intimated through WhatsApp. WhatsApp is received, but the informant is not present in the court. FR is accepted. Lordship, I have not received any intimation, any notice whatsoever, my lord. And this order is completely vague, my lord. In which number, which WhatsApp account the intimation is sent, nothing is recorded, my lord. Therefore, lordship, I want to protest the FR, my lord. At this stage, my lord, lordship may kindly remand back the matter, my lord, to allow me to file
No,
appropriate petition,
let us see the records. On what basis the court held that WhatsApp messages were received? Was there any material before the court or not?
Lordship, I have annexed the certified copies, my lord, and all the orders I have annexed, lordship. It is apparent, my lord, that proper service is not done, my lord. It is apparent from the orders itself, lordship.
Yes.
Yes, my lord, it shows that, my lord, WhatsApp it is given, but WhatsApp number is, no number was
Nothing
given.
is-
No number is reflected, whether, my lord,
Heard. Mr.
MM.
M.M. Zaman, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Pradeep Roy, impugning the order dated 27/2024, by which the final report submitted by the investigating officer in Gwalpara PS case number 12/2024 was accepted. Learned counsel for the petitioner has submitted that the petitioner had filed an FIR on, what was the allegation?
14, my lord, page number 14,
Filed an
FIR.
FIR before the officer in charge of Gwalpara Police Station on 6th February 2024. What was the gist of accusation?
My lord, the acquisition are, my lord, forgery and impersonation, my lord.
Allegation.
Cheating by impersonation and forgery. my lord.
Making accusation against the respondent by. No, the notice has to go. Respondent has to be heard.
Otherwise, lordship, I have a limited prayer, my lord.
Oh.
I just want to, because my lord,
Okay.
no opportunity of hearing is given, my lord.
क्या लिखा? respondent regarding cheating by impersonation as well as by commission of forgery and other accusations. On the basis of the said FIR, Goalpara PS case number 12/2024 was registered under section 120B/419/420/468/471 of the Indian Penal Code. The learned counsel for the petitioner has submitted that on 4/7/2024, the final report filed by the investigating officer in the aforesaid case was placed before the Court of London Chief Judicial Magistrate. And it appears that by the said order, notice was issued to the present petitioner. He further submits that no notice has been received by the petitioner. Neither any reflection of the receipt of notice is there in the case record. He also submits that later on, the order dated 11/7/2024 and 27/2024 shows that the notice was sent to the petitioner through WhatsApp message. However, there is no indication in the order sheet as to which mobile number the WhatsApp messages were sent and from which mobile number same were sent. It also appears that by impugned order dated 27/2024, the final report was submitted. And final report was accepted by the Learned Chief Judicial Magistrate Goalpara, inter alia stating in the said order that WhatsApp message has been received. However, he further submits that there is no indication as to who has sent the WhatsApp message and to which number. He further submits that no notice about the submission of final report has been received by the present petitioner, either through WhatsApp message or through any other means. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of the impugned order, it is clear that there is no indication as to under what provision the notices were sent. No, as to from which mobile number WhatsApp messages were sent to the petitioner and to which number same were sent. It also appears from the impugned order that there is no indication therein that before accepting the final report, the Chief Judicial Magistrate had applied his mind. On that count also, the impugned order is liable to be set aside. Stop. For the aforesaid reasons, this court is of considered opinion that the final report submitted by the investigating officer in the aforesaid case was accepted by the learned Chief Judicial Magistrate Goalpara without application of mind and without indicating that the notice, without assuring that the notice issued to the petitioner was duly served. Hence, resulting in prejudice caused to the petitioner as so. Had the notice been served on the petitioner would have availed the opportunity of filing a Naraji petition. But same could not be done. For aforesaid reasons, this court is of considered opinion that this is a fit case where in exercise of the inherent powers of this court under section 528 of BNSS, the impugn order may be interfered with. Accordingly, same is done. The impugn order dated 27/2024 is hereby set aside. The learned Chief Judicial Magistrate Goalpara is directed to issue fresh notice to the petitioner, and after ensuring due service of notice on the petitioner, it may consider the final report submitted by the investigating officer in the aforesaid case. This criminal petition is accordingly allowed.
I'm highly obliged. Item 46.
Wait, please, your lordships. My lord will kindly come to my lord the complaint based on which the affair was registered, is at page 20. My lord, I am a news anchor of News TV at CNN News 18. My lord. Now, in connection with that murder in Meghalaya, my lord, this particular complaint was lodged, page 20. My lord. Subject affair against unverified and highly defamatory statement by Miss Akansha Swarup, that is the Milord anchor, who is before your lordships. During an interview in a nationally broadcast segment aired on CNN News 18, the anchor MS Akansha Swarup made a blatantly unverified and highly defamatory statement against Ma Kamakya Temple, which is among the most sacred and ancient Shakti Peeths in India. During the telecast, Ms. Swarup stated on air, Noraboli is being practiced at Kamakya, and she made this statement without any official source, religious authority, or historical validation. She did not present this statement as an allegation or opinion, but as a declarative factual assertion. My lord, this is not correct. I'll come to this little later. This is absolutely wrong. It was rather an opinion of the person who was interviewed. This false narrative was further supported by Srimati Shrasti Raghuvanshi, the interviewee, the cousin sister of the deceased Raja Raghuvanshi, who agreed with the anchor's assertion and said, Noraboli is being practiced at Kamakya, and she knows it. The above statements are against the revered temple of Hindu deity Ma Kamakya of Assam, thereby hurting the religious sentiments of a particular community and disturbing public peace and communal harmony in the society. The remarks on Ma Kamakya demean the faith of a large section of the society and intended to outrage their religious feeling
by insulting the religion and religious belief, which may lead to riot in a scenario of diverse demography in the state. The act of circulating above mentioned objectionable content by the anchor is a motivated one, creating a sense of disbelief about the holy temple in the mind of the people as a whole, and creating anger amongst the devotees. This derogatory remark on the Ma Kamakya temple may likely to disturb public tranquility and may lead to serious law and order situation by inciting common public by spreading false information in general on the eve of and during the celebration of ensuing Ambubasi Mela in Ma Kamakya temple. In view of above, it is requested to register a case under section 196, 299, 299, 302 of DNS and take necessary action. Now, my lord, this was by the Inspector Chandan Das. Now, case has been registered under 196, 299 and 302. My lord, 196, I'll prima facie satisfy, my lord, it is not applicable. 299 is, my lord, of course, non-bailable, outraging religious feeling by insult or by insult of religion belief. Then 302 is uttering words to wound religious feeling. Now, if your lordship kindly takes 196 for a moment, before I take your lordship to other
What is the stage?
Notice has been issued.
Charge sheet has been laid.
No, notice.
35(3).
Milord, my humble submission is, Milord, before I take your lordship for other aspects, the transcript we have given, kindly see, Milord, what was the context, how it has been blown out of proportion, page 22. Because in the FIR 1 statement, lordship finds, C did not present this statement as an allegation or opinion, but as a declarative factual assertion. It was as if it was not an opinion or an allegation, but a declaration was made. Kindly come to page 22. Anchor. What is your opinion on this matter and why Raja's mother making such statements? Raja's sister, because both had Mongol dosh, that is an astrological defect, and heavy Shani on Sonam. We had advised rituals and prayers, but her family said they had already done them. Whether they actually did them or not, how would we know? What else can I do? Anchor. Raja's mother also claimed Sonam's family was in a hurry to fix this marriage. Now, her brother Govind Raghuvamshi has said that marriage was done according to Pandit's auspicious timing. Can you clarify why Sonam's family was in such a rush? Raja's sister. They were rushing everything. Even the engagement was hurried, and during wedding, they were in such a hurry that even when the photo shoot was going on, they kept saying, leave it, do it later, first finish the wedding rituals. It felt like they were trying to get the girl married off as quickly as possible. No parents usually rush a marriage like this. Now, this is the only paragraph. Kindly see me out. Anchor. That means Raja Raghuvamshi's family also said this could even be a human sacrifice. This suggestion was of the Milord Anchor, but it was basically originated from Raja Raghuvamshi's family. News 18 just spoke with Raja's brother, who said it might be a Noraboli because the attack came from behind and a garland was placed on him. Since they had gone to Kamakya, where sacrifice or human sacrifices are offered, is your family suspicious that this could be a tantric killing? Raja says, I don't know about all that, but yes, human sacrifice happens in Kamakya, that much I know. But what they thought or what they did, I have no idea. So where have I said, my lord, that the practice of human sacrifice is...
No, you cooperate in investigation.
I'll do, my lord. I'll cooperate. But lordship will protect me in the meantime.
What protection?
They will not take any coercive measure, my lord. No, my prima facie argument was subject to what your lordships may say, my lord. Will your lordships call for the whatever materials they have Till then, my lord, the proceeding should be, it's an abuse of the process of law, my lord.
No.
What? Huh? And kindly come to, for a moment, please come to 196(2) for a moment, my lord. It doesn't apply. Please see, my lord.
No, suppose there is no material in the acquisition.
Yes.
You have received notice under 35(3).
Sir, notice, no? It's not yet received. It has been issued, I have not received as yet, I am told.
So you
No, no.
cooperate in the investigation. Where is the case for this court to interfere at this stage?
No, my lord, my humble submission is prima facie 196(2) is not even attractive. Please have a look at 196(2) for a moment. BNS.
But we don't know what are the materials.
No.
Let the investigating officer do his work.
No, my lord will kindly come to 196(2), my lord. How is it even attracted, my lord? Kindly see, my lord, 196(2). Assuming the allegation contained in the complaint are correct, my lord.
No.
Whoever commits an offense.
Suppose something has been alleged in the FIR.
Yes.
Which does not attract any offense. It is for the investigating officer to come to a conclusion.
Lord, kindly see, my lord, these are, see, who is the informant? Informant
But
is
he is not the
so-
investigating officer.
Fine, my lord, but the whole thing is, my lord, these are not impartial things, my lord. These have all got political overtone. Anyway, I'm not even making that argument. Kindly see how a 196(2) is attracted, my lord. That's the main section. Kindly
No,
see.
my query is
No,
whether
Why should I face an ordeal which otherwise can be averted? Because that is why Supreme Court in Pepsi says, my lord, merely because the magistrate can give a discharge order, that does not mean in an appropriate case, court will not invoke power under either 482 or 226. My lord, what is the case? The bold statement in the complaint is that, my lord, it is my declarative view. Where is it my declarative view, my lord? This was the perception of the Raghuvanshi family that was being suggested. That's all. And that there is a practice going on is not mine. That's sister of Raghuvanshi's view, my lord.
no, what you are suggesting, you are
Asked.
you are asking.
No, your family members saying this. What do you say? How do you react to that?
No,
Only
you
that
are
much.
asking this court to do the investigation.
No, not really.
Let
What
the
I'm saying
investigation.
is, when there are prima facie, when my act does not constitute an offense within the meaning of 196(2), when my acts do not have the elements to constitute, my lord, outraging the religious feeling.
Out of 3 sections. There-
196 to outrightly goes, my lord. Kindly see. That's why I was trying to have your lordship's guidance. Whoever commits an offense specified in subsection 1 in any place of worship or in an assembly engaged in performance of religious worship or religious ceremonies shall be punished. Did I utter this, my lord? It was in a TV studio. It was not in a place where any religious performance are being performed. Or, my lord, in a assembly engaged in performance of religion. Or, my lord, in a place of worship.
Then it may be under 196(1).
No, my lord,
A.
they have invoked 196(2), my lord.
No, the police has registered a case.
Yes.
Suppose during investigation they find out the
That is
offense
there.
is under.
I'm not saying no, my lord.
Can that be a ground to interfere?
No,
At this-
my submission is, my lord, before giving that long rope to the police, would your lordships not ask them to, on what basis they have proceeded, my lord? If your lordship is satisfied on the next day, lordship will allow them to proceed. My only humble submission is, my lord, why should I face the ordeal when it prima facie does not attract the, my lord, offenses? That is my only humble submission for your lordship's kind consideration. My lord, here is a case, my lord, people under Article 19(1)(a), my lord, people have right to information to know the information, my lord. And I, being belonging to the 4th state, this is my primary duty. So a family is harboring a feeling. It is in that context I posed the question. Now, answers were given by the family members. It was not my answer, my lord. That's why I say the statement in the complaint.
To examine your contentions.
Yes. No, prima facie lordships will let them satisfy.
We will require the case diary.
Yes, case diary will be required. Let them send a scan copy of the case diary, my lord.
No, what's scan copy?
We'll bring the
The original case diary.
Oh, yes, case diary lordship can bring. my lord.
crime branch.
I'm sorry, item of court record.
But they will continue the investigation.
Meanwhile, my lord, my presence may be, my lord,
No, for that you have other reliefs, other recourses open to you.
No.
528,
no, that is there, my lord. Or I'll cooperate, but they will later not take any coercive measures, my lord.
no. You seek protection under the available legal,
Then in that case, we'll have to file an anticipatory bail application.
yes.
Okay.
Your contentions we may examine, but no
Yes.
interim relief. Heard Mr. K. N. Chaudhary, learned counsel for, learned senior counsel for the petitioner, assisted by Mr. S. P. Sharma, learned counsel for the petitioner, also.
But recently, that judgment of the Supreme Court, my lord, where 4 grounds has been laid down, my lord, where no offense is made out, even if allegation in the FIR are taken to be true, where allegation
No,
and other.
to appreciate this submission also, we will require the case diary. Because this is not a case where
Orders after receipt of the case diary, my lord.
what interim order?
It doesn't measure, my lord. Whatever lordship may consider deemed.
It can be decided, my lord, when if on receipt of the case.
No, it may not be necessary. Every day it may not be done. It's not that the court do not passes an interim order in an appropriate case. So my humble submission is, my lord, lordship will keep it for interim order after receipt of the case diary.
No, what nature of interim order?
Stay of the further proceedings, my lord. We say prima facie there is no case. That lordship will examine. Prima facie will satisfy lordship. 196(2) it is not there.
Okay.
Others also I'll show, my lord, I have not heard anybody's religious feeling. Or I have not tried to outrage the religious feeling of anybody.
We're praying for, no, this application under section 528 of BNSS has been filed by the petitioner, namely Miss Akanksha Swarup, who is praying for washing of the affair lodged by the respondent number 2, on the basis of which Crime Branch PS case number 4/2025 was registered under section 196 1A /299/302 of BNSS. Learned counsel for the petitioner has submitted that from bare perusal of the FIR, it would reveal that no ingredients of offense under section 196 within bracket 1A.
2, my lord. 196(2).
196(2), 299 and.
Yes, 196(2), page number 21, my lord.
Oh.
I do. Received and registered by Crime Branch PS case numbers 21 under section
196(2) instead of
182, 299 and 30.
no offense under section 196(2) /299/302 is being made out. And therefore he prays for washing of the FIR. And in the interim also prays for staying the investigation. So I have also heard, considered the submissions made by learned additional public prosecutor to appreciate the contentions raised by the petitioner, contentions raised by learned senior counsel for the petitioner. Perusal of the case diary would be necessary. Hence, call for the case diary. Please this matter.
Let it be on 14th.
14th of October. The prayer for interim relief sought for by the petitioner shall be considered
Yes.
only after receipt of the case diary.
Deep Lord.
Issue. Who are the parties? You are appearing, you are representing both the,
Is by name, my lord.
no necessity of issuing notice. As learned additional public prosecutor, no necessity of issuing formal notice. As learned additional public prosecutor may represent both the both the respondents. List as directed.
Item 47.
Deep Lord.
This is an application under 520 of a quashing of an FIR, my lord. But here the my lord, the FIR is at page number 95. And the operative portion of the FIR is from page number 97, my lord. My lord, the contents of the FIR is necessary to conclude that whether the quashing of FIR will be done. On, my lord, if I may, my lord.
Page number?
97, my lord.
Yes,
My lord, if I may, my lord. On
yes.
6/1/2024, complainant Ashok Kumar Bengani, proprietor IMX Global, so and so had lodged an FIR at the PS stating that Nutrition Industries Private Limited engaged in the production of wide range of edible oil, beverages, medicines, and miscellaneous and doing business in Lower Assam area. Prior to signing an agreement with the aforesaid company for mother depot, the
What is your
complainant had-
name? Who are you?
I'm petition number 1 and 2 are the directors of the nutrition company.
Okay,
And petition number 3, 4, 5 had no role to play in this company, my lord, and they had no role in the offense committed, my lord. So, my lord, basically the nature of the case is only as a civil nature, my lord. My lord, need to consider 3 aspects, my lord, whether the dispute between the parties is of civil nature.
now what is the acquisition made?
The acquisition is that made that, my lord, after 13/10/2022 agreement, we have the allegations in the FIR is that we have sold the expired products to the distributor, that is the Ashok Kumar Bengani. And then we are changing the addresses, and then we have siphoned the security, and when they have tried to cancel the agreement, we have siphoned the money to our other companies. So, my lord, the contents of the FIR is necessary to conclude what is there. My lord, may give some 5 minutes, my lord, if I can read, my lord. My lord, it's a long FIR, my lord.
Yes.
So, my lord, prior to signing of the agreement with the aforesaid company for mother depot, the complainant had a business dealing with the company as CFA on commission basis. On 18 July 2022, the complainant had ordered nutrition products worth 11,60,563 from the aforesaid company and stocked it for a sale in the market. This is important, my lord. Prior to signing of 13/10/2022, they were in the business, my lord. And I can show it from the annexures that they had an agreement also on 17/2/2022 that it has to be, this item has to be sold in the commission basis, my lord. Then thereafter, my lord, the company had sent complainant email on 29/9/20 requesting the complainant to sell the stock from complainant and to one MS Moni store situated at so and so. As per the order, particulars and rate fixed by the company, and accordingly complainant processed the order. But the company did not pay the amount into complainant account towards the said order. For becoming a mother depot for the company, complainant have entered into an agreement with the company for functioning as mother depot of the company under certain terms and conditions. As per the agreement, complainant deposited 20 lakhs as security deposit. Accordingly, complainant had deposited 1 lakh on 1/11. It is not 10 lakhs, it's 1 lakh, my lord. The typography letter. 1 lakh on 1/11/2022, 1 lakh on 5/11/22, 5 lakhs on 14/11. And my lord, this has been again typically and rupees 3,51,545 on 15/11/2022, and 11 lakhs which was taken from the company was adjusted, my lord. Was adjusted. My lord, on the next page, after the inception of the agreement, the company is to provide complainant with rent of the godown for 1,200 square meter pitching area at the rate of 20 per square feet, amounting to rupees 24,000 per month. For 5 months, which is equal to 1,20,000. But the company has not paid the same to the company till now. Besides that, the company has also paid us rupees 7,000 per month for one unskilled employee, but the said expenses have been borne by me till date. As per the agreement, the company has agreed to pay 12% interest on the deposit per annum. The company, with an intention to cause loss to company, had transferred some non-saleable, expired and short-dated goods by nutrition industry from Bhubaneswar and Guwahati to my godown, being a mother depot. Complainant had communicated the above facts to the company to take the stock of the goods which were transferred to the complainant go down and make an assessment and thereafter dispose of the expired and non-saleable item. But till that, no representative from the company has come to the complainant go down to inspect the same. After execution of the agreement for mother depot, the company has started to avoid complainant. As per the said agreement, is required to dispatch the goods to the mother depot as per the market requirement. The company stopped supplying the material goods, and as such, I am unable to do the business, which has caused tremendous loss to the complainant business. The company has been changing the registered address frequently in order to cheat people. As of now, the company has changed their address twice. While executing the company, they have stated Bhardeswar Hooghly as their registered offence as per Purbachan Palli, PO Angush Hooghly, and recently they have communicated by email department annual report that they have shown their address as first floor. Malad, this we have communicated. We have not done in. We have not hiding that we are changing the address, Malad. Malad, that another crucial part, Malad. Directors of the company Nutrition Private in convenience with Sudarshan Chaudhary and Samiran Datta. Malad, these two persons are necessary, Malad. These were the one who are duping several other clients, including the respondent number 2, in regard with the amounts, Malad. So Sudhar Samiran, represented as Chief Executive Officer and General Manager of the company, has cheated and fraudulently taken away complainant hard-earned money of rupees 20 lakhs. In the name of the business promotion as mother depot from the company master data, it is found that one of the director of nutrition industry, that is Mithun Sikdar, is a common director of Elephanta Developers, Omkrit Builders, and having registered of him so-and-so, so-and-so, so-and-so. Dipsika Sikdar, another director of nutrition company, is a common director of Elephanta Developers. Both Mithun and Sikdar siphon of the money funds of nutrition industry and invested into two companies, namely Elephanta India and Omkrit, where both Mithun Sikdar and Dipsika Sikdar are directors. Mithun Sikdar, Dipsika Sikdar in convenience with who are the respondent number 3 and 4, 5, Prasenjit Biswas, Gauranaran Mukherjee and Sukhendu Mukherjee, along with Sudarshan Chaudhary and Samiran Datta, both pretends to be the CEO and general manager of the nutrition company, respectively, committed cheating to the informant and misappropriate the invested money for the personal gain, hence the case.
The informant has paid you 20 lakhs.
And a security deposit.
Okay.
For
What
the
is your
agreement dated 13/10/2022.
What is your submission?
So my humble submission is that these two persons, Samiran Datta and Sudarshan Chaudhary, as written in the FIR, my lord, they are the one who are committing fraud. They are the one who are committing, because my lord, we come to the agreement dated 17/2/2022.
No. What is your submission? You tell me.
My submission is that the Sudarshan Chaudhary and Samiran Datta are the one who are committing fraud, and petition number 1, 2, and had no role and had been kept in the dark. And 3, 4, 5 had no role to play only, my lord. Because, my lord, there is a company notice which were published prior to the FIR, my lord. My lord, may come to the page number 87, my lord.
No, why this court should interfere in
the court should interfere because we had no role to play. We are not siphoning the money or anything, my lord.
But accusation against 1 and 2 has been made in the FIR.
Accusation of 1, 2, 3, 4, 5 has been made in the FIR. But the thing is, my lord, there's no offense we have committed, my lord. My lord, may please come to the page number 87, my lord. 87, my lord.
No, whether you have committed offense or not, that would be revealed during investigation.
That's what, my lord. I want to show it to from the annexure, my lord. From page number 87, my lord. Why the Sudarshan Chaudhary and Samiran Datta has committed the offense? Because petition number 1 and 2 had no role to play, my lord.
No.
And more so, my lord, it's a nature of a civil nature because civil suit has been filed, my lord.
That may be a 1 gram.
So it is civil suit, my lord. And being a director, it is not necessary that he will be liable for the offense, my lord. Because the offense has been committed by the Sudarshan Chaudhary and Samiran Datta.
Anything.
My lord, may come to the page
The
number
main
87.
accusation is they have violated the terms of
It's a main
agreement.
breach of contract, my lord.
Breach of contract is there, and but in the
pair portion, they have mentioned PS case number, but what PS, I have not found yet,
This PA, in fact, the FIR was filed on 6/1/2024, and after more than
Yes.
1.5 years, we have received the notices, my lord.
Page 26.
The notice is the
Maybe,
page number.
maybe got to PS, but page 26, they mention as FIR number 010016. And PS case number 16/24, which PS?
This,
my lord?
no, it will be
If
found
you
from
have
the-
received notice, you appear,
Yes, we have appeared, my lord.
you have already appeared.
We have appeared, 3, 4, 5 have appeared, 1 and 2 are undergoing some medical treatment. They will be appearing in the month of October. We have filed an anticipated bill and we have, the interim protection has been granted, my lord.
Okay, okay. Heard Mr. A.R. Barua, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, and an additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely 1, 2, 3, 4, and 5. Namyar Prasai Logo. He praying for quashing of the FIR lodged by the respondent number 2, on the basis of which police station?
Gorsuk Police Station, my lord.
Gorsuk PS case number 16/2024 was registered under section 120B/420/406/418 of BNS. Learned counsel for the petitioner has submitted that the main accusation against the petitioners in the FIR is that their company had violated the terms of agreement entered into between the company and the informant. Learned counsel for the petitioner submits that the accusation made in the FIR are predominantly civil in nature, and this FIR has been, criminal proceeding has been instituted only to pressurize the present petitioners. Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on, give a fixed date. Putul,
28 November.
28?
October.
28 October. Let the case diary of Gorsuk PS case number 16/2024 be called.
In the meantime, I will.
List according. You are already under protection.
49. 20.
28 October.
The petitioner is challenging the issuance of process against him and the consequential proceeding thereto arising out of the import order dated 30 April 24, which your lordship will find at page 45. Under section 406 of IPC.
What is your ground?
Fact of the matter is that both the petitioner and the respondent number 2, who is the complainant before the learned trial court, is the divorcee. And
Page number?
Page number, lordship will find
Impugn order is page number?
45, Annex 6.
What is your?
Ground is that, my lord, the issuance of process is in violation of section 202 of CRPC, old code and new code in 225 of BNSS. Because it is on record that the petitioner is the jurisdiction whose address has been recorded as Tezpur, but the proceeding has been initiated at Mongolpur.
and
So inquiry has been done.
not
One,
done, not done.
one CW was examined.
On the initial deposition of the complainant witnesses has been examined. But no inquiry from,
No
the-
initial deposition, complainant is examined only under
Examined.
section 200.
yes. But
The witnesses are examined under
Examined.
202.
No, 202 has not been adhered because under section 200, initial deposition recorded and process has been issued thereafter.
No,
Then
it reflects that CW1 has been examined.
Yes, examined. But while my case is that when I am residing outside the jurisdiction of the territorial jurisdiction of the landed magistrate.
Where is the
then it-
complaint?
Complaint you look at Annexure 1.
Page number?
Page number 22, 2 onwards,
Page number?
22. Double two.
How many witnesses have been?
Only herein two witnesses has been projected. Who is sister only. Complainant respondent number 2 herself and two witnesses are one Gitika Das and Ajit Mehdi. Those are not examined. Only 3 Meenakshi Mehdi has been examined.
Court examined Meenakshi Mehdi under 202.
200.
202.
So mandate of 202 is that you lordship will find it in my petition at page number 16, my lord. 16 I have averred in details, my lord. In 16 the mandate of, sorry. In 15, in 15 of this petition. Section 202 speaks that empowers the magistrate to postpone the issuance of summons or warrant within bracket process against an accused person when a complaint is filed. The magistrate can either conduct an inquiry into the case or direct a police officer or another suitable person to investigate to determine if there are sufficient ground to proceed. This procedure is mandatory when the accused resides outside the magistrate jurisdiction to prevent unnecessary harassment. And so far as the significant aspect of this case is that, my lord, the house on which search has been paid, search warrant has been paid, is in the custody of the present respondent number 2 herself, which is your lordship will find from the annexure 9. Annexure 9 will speak in page 55, level 5. A police report where my house has been forcefully occupied by the respondent number 2, I have lodged a police report in Tezpur police station. And during the course of investigation, this report has been laid before the learned court of CGM Sonitpur. And this report says that the house has been occupied by the respondent number 2, namely Rakhi Das herself. So question of any search warrant, if issued, it will amount to abuse the process of court of law. Because the entire articles, those are, although appliances are in the custody and it may be used or misused by the respondent number 2 herself. So there is no meaning of any proceeding of the, in the learned trial court under section.
When is the next date fixed?
Next date fixed, so far as instruction I received on 13th of October in the learned trial court. And I would like to rely on judgment of this honorable court. Your lordship will make it clear position.
Where is the statement of?
Lordship will kindly see the para 47 and 48. This honorable court. Judgment.
What it states?
What I have submitted. Very short paragraph, my lord. Very short paragraph. Page 47 and 48.
Where is the deposition of PW1, CW1?
Yes, lordship will find annexure 4,
Page number?
55 onwards.
Heard Mr. R.C. Paul,
April.
sorry, heard Mr. A. Paul, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner Manoj Paul, who is impugning the order dated 30/4/2024, passed by London Judicial Magistrate First Class Darong in CR case number 602/2022 under section
406.
406, whereby the court took cognizance of offense under section 406 against the present petitioner. The learned counsel for the petitioner has submitted that the trial court has erred in taking cognizance against the present petitioner without following the mandate of section 202 of the CRPC. In as much as the petitioner is not a resident of the place within the territorial jurisdiction of the court which took the cognizance. The petitioner resides in the district of Tejpur, Sonitpur, whereas the cognizance was taken by a court having territorial jurisdiction in the district of Darong.
No, my lord. May I interrupt, my lord? The house of the petitioner has been projected at Tezpur, but presently he is dispossessed by the complaint respondent number 2 herself. So now he is residing at his own paternal home at Kalaigaon, where I have received summons.
Darong.
Yes, no, it is Udalguri district. In Udalguri district.
Learned counsel for the petitioner has submitted that the petitioner is presently staying at
Singrimari Bagicha, Kalaigaon.
Kalaigaon in Udalguri district. So, though the learned counsel for the petitioner has submitted that the mandate of 202 of the Code of Criminal Procedure has not been followed. However, on perusal of the records, it appears that CW1 was examined under section 202 of the Code of Criminal Procedure by the trial court. It also appears that though 3 witnesses have been named in the complaint petition by the respondent number 2, however, only 1 has been examined. Now the question as to whether all witnesses are required to be examined under section 202 CRPC or it is left on the court to examine such number of witnesses as it deems fit to examine under the facts and circumstances of the case is required to be examined in this case. Hence, issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by registered post with AD as well as by usual mode.
My lord,
with the
I would like to submit that there is a proceeding different proceeding between this respondent number 2 and the petitioner in the Court of Additional Sessions Judge FTC Darang. So may I serve Dosti service upon her because through her advocacy counsel or herself, because she resides two addresses at Dorong and in my occupied house at Tezpur. So it is very difficult to notice will move here. and there.
You issue notice in both the addresses. The learned counsel for the petitioner submits that the respondent number 2 resides in Dorong, and as well as sometimes she resides at Sonitpur. The petitioner is directed to take steps for issuance of notice on both the addresses of the respondent number 2. Let the scan copy of the case record of CR case number 602/2022 be called for. Let this case be listed on 13th of October.
In the meantime, my lord,
No, we are fixing it on the same day when the trial is fixed.
no, it would be the of justice if your lordship would fix it any before or later, because the before court will close, our court will close. It would be
Okay.
better to
Yes,
just
sir.
after some time.
28th of October.
In the meantime,
No protection. 202 has been followed.
actually mandate of 202 is. my
That we will
lord,
consider
regarding jurisdictional error committed by the learned magistrate.
during
while
hearing.
she process.
During hearing, that will consider.
All right. Item 40. Obliged.
Right, little lordship. My lord, we have read to quash the proceeding of MR case number 9624, page 13. And also the impugn order that is dated 24/7/25, page 74. The crux of the case is this, my lord. This present private respondent number 1 and 2 have filed already 8 cases. MR case, 8 cases have been filed for the same plot of land and for the same, and both the parties are same. Parties are same, lands are also same. And the magistrate concerned, I have made him a party by name because he knows about the quashing of the matter by the Honorable High Court, which has been reflected in the order sheet. Now, I am inviting your lordship, kindly see page 67. Operative portion, page 68. This is
Why
the-
magistrate has been named as party?
because, my lord, he knows that already the Honorable High Court has quashed the proceeding. And that has been reflected in the order that lordship may kindly see in the case page 67 onwards. Page 67 onwards, that he has mentioned the objective, the order, first kindly see order, page 74, madam. And operative portion, page 76. Kindly see the schedule of the land. Page 76. Schedule of the land. Mauja Kopahbari, Kisam Usim Samorali. PP number 113, DAG number 456. Land measuring 2 biga, bounded as so and so, Moinuddin, etc. Now, kindly see now page 15 and 73. 15, first kindly see page 15. This is the land, page 15, patta number 113, DAG number 456, Samorali Kismat Kopahbari Mauja Huzai district. So exactly the same plot of land there is title suit, it's pending. This title suit may be seen page 19, page 46. Page 46, and listen now.
Between the same parties.
Same parties. Page 46, kindly see for a moment how the magistrate is, parties are advised by the magistrate to file cases, I will pass order. There is evidence or recording also with the party. Now kindly Ismail Ali. Ismail Ali is one of the petitioner here. Now Samsul Haq is the defendant, respondent here. And on the death of Shafiquddin, so his legal heirs, they are the party in the title suit number 7823. Then there is another title suit, that is page 55. Title suit number 52, 2023. So this, the suit land of this MR land, which has been passed by the learned magistrate, that lordship now kindly come to page 73. There are two title suits are pending because there are nearly 12 bighas of land, which are the subject matter. Here is only 2 bighas. In next case is coming day after tomorrow or 2 or 3 days. Now kindly see page 73. There is the application submitted by the learned advocate of the second party. Second party means the present petitioner, wherein they have submitted a judgment of Honorable Guwahati High Court quashing a 145-146 case order over the same disputed land, and hence, since the Honorable High Court, Guwahati High Court, have already quashed a order being purchased from entering the DL, the order issued by the undersigned on 4/11/24 is hereby cancelled. Now kindly see his order, cancelled. He has cancelled, but at the second time he says, and O.C. Murazar is directed, his order to execute bond the parties to mention peace. Next date is fixed on 7/12/24. Now here is controversial order. First order is that, as per Honorable High Court's order, what order I have earlier passed, that the same has been cancelled and the High Court has quashed the entire proceeding. But at the same time, he says that parties shall execute bond that they would not enter in the suit land.
In the same case.
In the same case. Now, that is why, my lord, we have made the magistrate as a party. Not only this case, many cases. Already there is another case, which I have shown your lordship. The order, that your order is there, kindly see, page 67. Here one order we have annexed, but number of the cases are given. Page 67, can you see?
Yes.
67, this is another case where your lordship has passed the order.
It is MR case number 215.
Yes. 215, it is one of the case. 215 is one of the case. And lordship has stated the other proceeding. That is page 69. Page 69.
Now what is, where is the impugn order in this case?
Impugn order, that is
74.
my lord, page, last page, say 76. As such, second para, as such, the undersigned drops the case with the instruction, he drops the case, but again says with an instruction to concerned OC to stop both parties from entering the disputed land till the disposal of the title suits in judicial court, and OC Murazar to execute bond from both parties to maintain peace. So when the case is dropped and title suit is pending, parties have the proper place to adjudicate their remedies in the title suits. So that is why Honorable High Court quashed the proceeding. Now, how many cases he has filed? I have given a list here.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner. This state is a party? No,
No, I said only registered by name.
this application under section 528 of BNSS has been filed by the petitioners, namely Ismail Ali and Atharuddin, praying for quashing of the proceedings of MR case number 96/2024 under section 107/145
And also the order dated 24/7/25.
ARPC. The petitioner has also impugned the order dated, where is that order?
Yes, 76.
Order dated,
24/7/25.
but you are not prohibited from entering. You are only,
Yes, that part. Because I have purchased the plot of land, I have annexed all the cell deeds here.
where is that prohibition?
As such, the kindly 76 second para, as such the undersigned drop the case with the instruction to concerned OCs to stop
Prohibiting,
both the parties.
prohibiting the petitioners from entering into the disputed land till the disposal of title suit pending between the parties. Learned counsel for the petitioner has submitted that there are earlier several cases pending before the parties to this case, and on a few occasions
73, page 73.
on that there are two civil suits also pending before the court of competent jurisdictions bearing title suit number 78/2023 and title suit number 51/2022 between the same parties in respect of the same disputed land. However, in spite of that, by the impugned order dated 24/7 2025, the learned additional district magistrate Hojai has directed the officer in charge of the
Murazar Police Station.
Morajar Police Station to prevent both the parties from entering into the disputed land till disposal of the title suit, though no such injunction order has been issued by the civil court in this regard. Learned counsel for the petitioner submits that when the matter is pending before the civil court of competent jurisdiction, the learned additional district magistrate Hojai does not have any jurisdiction to initiate a proceeding under section 145/107 CRPC and pass the impugned order. Stop. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by registered post with ID as well as by usual mode within a period of 7 days from the date of this order and returnable after 4 weeks. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraph. And prima facie. And prima facie. No, continue. As discussed in the foregoing paragraph, further proceedings of MR case number 96/2024 pending before the learned district magistrate Hojai,
Additional district
additional district magistrate Hojai shall remain still.
and order, man, and order.
Still, when proceeding is stayed, then order is almost
Because proceeding is now
is
dropped.
is stayed.
That's why my lord order is
The
just.
execution of the impugn order dated 24/7/2025 passed in the MR case number 96/2024 shall also remain suspended till next returnable date.
Hello.
This accordingly.
41. May I please the motion?
Yes,
My lord will kindly come to my lord. Page 14, that is the FIR, my lord, against us. My lord. One for me. The allegation of rape and section 6 of POCSO is there, my lord. I am for the my lord accused number 1, my lord. I am 17 years old, my lord. And at the time of my lord filing a bail application before the concerned court below, my lord, I closed one school transfer certificate, my lord. Lordship will find that at
you are on bail.
on bail now. Only my prayer is that, my lord, since my school's transfer certificate was supported by the my lord admission register of the school, and the concerned headmaster was also examined, my lord. Therefore, my lord, he should be declared as child in conflict of law, my lord. And at this stage, I am praying before your lordship to issue a notice only. That's all. Let them appear.
Heard Mr. Z. Hamad, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This prayer you have made before. You were granted bail by which court?
By the Lynott court below, my lord. That is, I have already.
You have taken the plea of juvenility before that court.
Yes, I took the juvenility, but that was declined, but my bail prayer was granted. Bail has been granted. But regarding the CCL, child in conflict of law, my lord, that has been rejected.
You have challenged that order.
Yes, that order has been challenged.
You-
No, that order has not been challenged.
You have to challenge that order.
But my prayer before your lordship is that since on the basis of materials that have been produced before your lordship.
No, you
my lord.
cannot directly come without challenging the, if a court has
Yes, my lord.
conducted an inquiry and come to a finding that you are not juvenile, unless you challenge that order.
My lord, there are some developments took place during the my lord, pendency. I mean, during the course of trial, my lord. They said they constituted a medical board and several dates were fixed, my lord, and accordingly, finally, on the day of my lord, submission of report, the medical board had said that the boy would be more than 18 years of age, my lord. And that much, my lord.
So that order has not been
Therefore, I
challenged.
have prayed before your lordship, my lord, that message on the my lord materials available on record, my lord. She will kindly call for the records.
No, you have not challenged that order.
That order is not challenged, yes.
You have to challenge that order, which has already,
My only prayer is that, my lord, she will kindly examine that part and whether I should be declared as a child in conflict of law. That much only, my lord. I am ready to face the trial otherwise.
unless you challenge the order which held you as a juvenile,
I have
how
not
can you parallelly instate?
My prayer is rejected that I am admitting, my lord. But
You challenge that
on the
order.
other way, my lord. Other way, my lord, because of the my lord, medical board's report, my lord. My lord, I have not been declared as that I am my lord, more than 18 years old, my lord. That has been declared by the medical board only, my lord, not by the Lynott court below.
Suppose lordship passes an order in his favor.
That order,
That order has to be set aside. Lordship.
yes,
Otherwise that.
and that order you have not challenged.
That order has not been
12,
put to
11,
challenge.
24, annexure 11.
Yes, annexure 11.
Unless you challenge that order, this inherent jurisdiction may not be exercised by this court.
May I pray for one thing, Milord?
Yes,
May I be allowed to amend this petition if possible?
okay.
During the
Heard
pendency.
Mr. H. Hamad, Z. Hamad, learned counsel for the petitioner. Or also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has prayed for allowing the petitioner to amend the instant criminal petition to bring on record certain facts which are relevant for this case, this matter. The prayer is allowed. The petitioner may file an amended criminal petition before the next date fixed.
Right.
Let this matter be listed
Just after the vacation.
after puja vacation on a date to be fixed by registry.
Deeply appreciated.
Item 42.
I may be allowed to withdraw the present.
Heard
Actually, but-
Mr. B. K. Gogoi, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition. The prayer is allowed. This case is dismissed on withdrawal.
Not a liberty.
With a liberty to approach this court by filing an appropriate application.
Obliged.
Item 43.
May I please also? Well, in this case, my FIR space number 30, my lord, this is having my lord eloping of a girl lordship. Thereafter, lordship, I granted bail this bail my lord by this honorable court. Thereafter, my lord, after granting my bail, my lord, the police called me, my lord, to me and my brother. This is the petition number 2. Thereafter, from my both, my lord, they seized my mobile. Lordship. For what purpose, I don't know, lordship. It is page number 13 is the my lord FIR, my lord.
We will call for a report, Mr. Shah.
We also approached for a Lanet Court below, lordship, at page number 21. Page number 21, my lord, kindly see, my lord. My lord, the
Yes.
IO stated that, my lord, petitioner do not have any document pertaining to the my lord mobile phone. Whereas, my lord, I have already submitted, my lord. Now, my lord, I am a shopkeeper, my lord. My customer number is there, lordship. They are, my lord, absconding, my lord. I could not contact them, lordship. My lord, some urgent order required.
Why mobile has been seized?
Lordship, very interesting, my lord. FIR space number 13, lordship. No way connected, my lord. Girl eloping, my brother eloped. I was not arrested. Petition number was not arrested, although he is.
Yes, Mr. Sharma.
Also, the IO's report submits lordship with the mobile phone that is already sent to FSL.
My lord, common, my lord.
And that report has not yet been received, so the.
Okay, then call for a report.
Lordship, my lord.
It has to come. Heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners Barkat Ali and Ahmed Ali, impugning the order dated 15/7/2025 passed by learned Judicial Magistrate First Class Dhubda in Judicial Magistrate First Class Gwalpara in Dhubdara PS case number 21/2025. By the impugn order, the prayer for Jimma of the seized mobile made by the petitioner was rejected. Call for a report regarding seizure of the mobile in this case, as well as also as to whether the grant of Jimma to the mobile to the petitioners would in any manner hamper the investigation, and is it necessary for the fair completion of investigation? Let the report be called, placed before this court on the next date fixed. Let this case be listed on 22nd October.
Quickly, your lordship.
44.
May it please the lordship. Petitioner has approved with a very limited prayer, but before coming to the prayer, let me take the facts, your lordship. This petitioner number 1, your lordship, he was having an affair with the informant. And on 8/3/2017, your lordship, the informant left her house and came to the house of petitioner number 2, who is the auntie of the petitioner number 1. She stayed there for about 3 months. Her parents tried to take her away, but she did not. Ultimately, they convinced her and they took her away after about 3 months. And then an affair was lost, which is at annexure 1, page number 10, your lordship.
No, on what ground you are seeking quashing?
Now, lordship, actually what happened after filing of this FIR, your lordship, charge sheet has been filed. The police never visited his home. He was never asked for. And after receiving the notice, your lordship, from the learned court below, he appeared through an engaged counsel and could come to know that he has been shown as an absconder. Now he has apprehension, he wants to face the trial, but he has apprehension that if he appears, your lordship, he may be put behind the bar, your lordship. So the petitioner herein is ready to and willing to face the trial. Actually, nothing had happened as a result.
What relief you are seeking?
If he appears, your lordship, the learned court below is
You are seeking quashing of the,
that I have come for, but I am not.
but you are submitting something different.
Differently, your lordship, because actually he wants to appear before the land court. and face
You
the-
appear. Let the try, no warrant has been issued against you.
One bailable warrant is there.
So when is the next date fixed?
25th,
You appear before the trial
Yes, yes.
court and pray before the said court for any relief. You are not pressing the quashing prayer.
I am not watching.
Heard Mr. M.H. Laskar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner namely Ajoy Sinha and Sandhya Rani Devi, praying for quashing of the charge sheet, quashing of the proceedings of PRC case number. No POXO is there.
POXO is not. In fact, POXO is not also applicable because your lordship, she was studying in CTC part 2 at that time. She was above 18. In the FIR itself, it is written she is.
Proceeding of PRC case number 124/2023 under section 366/376 of the IPC. Learned counsel for the petitioner has submitted that though the petitioner is not pressing for his original prayer made in this criminal petition, and instead he is willing and ready to face the trial. However, he is apprehensive that as the petitioner, both are shown as absconder.
Yes. Shown as absconder.
Both the petitioners are shown as absconder in the charge sheet. They may not be granted bail. What is the punishment under 376? How much?
10 years.
Stop. As the petitioners are not pressing for their original prayer made in this criminal petition, and as they are ready to appear before the trial court and face the trial, this court is of considered opinion that no, this criminal petition is disposed of with a direction to both the petitioner to appear before the trial court on the next date fixed, that is
25 your lordship.
25/9/2025. On their appearance before the trial court, the petitioners may seek any relief to which they are legally entitled to. With above observation, this criminal petition is disposed of.
They will appear within 10 days because if this order is.
No, there is no coercive steps. Only bailable warrant of arrest was issued. And that you have received.
I have also appeared to an engaged counsel and I myself has.
So you appear and pray for relief on the next date fixed. Instead of within 10 days, you appear before the fixed date.
Obliged.
49.
Oh, sorry. Petition on.
Should we take it up now or after vacation?
My lord,
Because it may require long submissions.
my lordship may take up after vacation, but lordship, I pray for any interim lordship because involvement of this amount of the contraband is minuscule lordship. As far as
Is
minuscule involvement lordship, minuscule percentage.
no, that is your submission. If that is agreed to, then your case,
Judgment of the Honorable Apex Court as well as from the other high courts and your lordship judgment lordship. That is why lordship. On that occasion, last occasion, I have shown the notification lordship. Exception is there.
yes, otherwise we will dispose it of.
Sometime.
It will take some time because there are many matters pending. And how much time will you take?
My lord, on last occasion, lordship, I have mentioned all these things. Lordship asks Learned PP to bring anything if required, lordship. Because I have placed all the judgments, lordship, lordship order and Apex Court order and the other courts. And the notification also I have brought with the additional affidavit.
Whether case diary is there,
Yes,
FSL is there.
FSL will be required otherwise also.
But we have
On what basis you have held that the codeine seized in this case falls within the category of manufactured drug?
Lordship, there are judgment and also notification, Lordship. If Lordship is keen to dispose of, then only Lordship would like to make the information. Otherwise, it will take some time, Lordship.
It will take the remaining time.
Yes, it will take the time.
We'll take it up on the first date of.
Well, in the meantime, I may be some interim protection is required also. If it will go against me, I'll surrender my lord.
No, for that, this court has to call. Okay, let us hear it. Yes, your submissions you have made.
My lord, on last occasion, I have shown the quantity, how it come to the minuscule amount lordship percentage. That is, I have mentioned in my paragraph 8 of my additional affidavit, 70 numbers of bottles, and after the calculation lordship, I found that 0.2%.
Okay, that calculation is there.
And as per the notification lordship, as per notification, I found that 1995 notification is there. 85 notification is the exception as per 35 of the column lordship. That exception is there if regarding the codeine phosphate and other article, codeine phosphate recovered lordship, then exception is there. Except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drugs per doses unit and with a concentration of not more than 2.5% in undivided preparation and which have been established in therapeutic practice.
And do you have any objection in giving interim relief? You have objection. Okay.
With his objection, my lordship may pass the order. If lordship, I am local person, I'll surrender, man.
We'll dispose it of. Yes. What is your submission?
My submission is that, my lord, whatever.
Okay, your submission, we have heard on the last occasion also. The public prosecutor, Mr. Sharma. Yeah, you have given supporting cases also on this.
Cases I have placed before this honorable court, lordship.
Can you give a
See,
list,
I'll place the list, lordship.
even if possible in handwritten, that which judgment you are relying on what point?
Lordship. Only,
Yes, Mr. Sharma.
Yes, Lordship, here the notification that they are showing, Lordship. Lordship will kindly come to entry 35. Just to clear it up, Lordship.
Come to
They have annexed it in the additional affidavit, Lordship.
page 37.
Page 37.
Yes.
Entry 35, they are placing reliance on this, Lordship. Methyl morphine, commonly known as codeine,
Yes.
and ethyl morphine, and their salts, including thionine and all dilutions so and so there, except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drug per dosage unit and with a concentration of not more than 2.5% in undivided preparation. Now the important part is, Lordship, and which have been established in therapeutic practice. Lordship may kindly take note of that. Therapeutic practice. Next, Lordship, if Lordship kindly takes up the schedule of the NDPS Act, Lordship. Where the table starts, Lordship, this is the notification of 2001.
Yes.
This is, Lordship, notification of October 19, 2001. Lordship has found it. Then Lordship will kindly come to the last page, the note. Note part, Lordship will find there are 4 notes, Lordship, 1, 2, 3, and 4.
Yes.
Note number 4, Lordship will kindly see.
Yes.
The quantities shown in column 5 and column 6 of the table relating to respective drugs shown in column 2 shall apply to the entire mixture or any solution or any one or more narcotic drugs or psychotropic substances of that particular drug in dosage form or isomers, esters, ethers, and salts of these drugs, including salt of esters, ethers, and isomers, wherever existence of such substance is possible, and not just its pure drug content. This note 4, Lordship, it was incorporated in this act, Lordship, by this notification SO 2941E dated 18 November 2009. I have placed the relevant portion, Lordship. Lordship may kindly take the note number 4 was inserted, Lordship, here.
Yes.
So I have already placed this, Lordship. Now, Lordship will kindly take up one judgment and reason, Lordship.
This is the division bench judgment of the Supreme Court. Lordship. Basically, it's on the same facts and circumstances, Lordship. I will try to be brief as much as possible, Lordship. Lordship will kindly come to page 10, paragraph 10, I'm sorry. Paragraph 10, Lordship. Yes, paragraph 10 for a moment, Lordship will kindly see. At the very outset, the aforementioned submission of the learned counsel is liable to be rejected inasmuch as the conduct of the appellants in having transported huge quantity of 347 cartons containing so-and-so in each carton of 100 ml, phenicidyl cough syrup and 102 cartons, each carton containing so-and-so, transportation cannot be heard to state that he was not expected to fulfill any of the statutory requirements either under the provisions of Drugs and Cosmetics Act or under the provision of NDPS Act. Paragraph 11. It is not in dispute that each 100 ml bottle of phenicidyl cough syrup contained 183.15 to 189.85 mg of codeine phosphate, and the each 100 ml bottle of Ricodex cough syrup contains so-and-so of codeine phosphate. When the appellants were not in a position to explain as to whom the supply was meant, either for distribution or for any licensed dealer dealing with pharmaceutical products, and in the absence of any other valid explanation for effecting the transportation of such a huge quantity of the cough syrup, which contained the narcotic substance of codeine phosphate beyond the prescribed limit, the application for grant of bail cannot be considered based on the above submission made on behalf of the appellants. Next, paragraph 12, Lordship. The submission.
No,
of the-
in this case, their contention is that
regarding the.
it is not beyond the prescribed.
Yes, Lordship, kindly bear with me.
Yes.
Paragraph 12. The submission of the learned counsel for the appellants was that the contents of codeine phosphate in each 100 ml bottle, if related to the permissible dosage, namely 5 ml, would only result in less than 10 mg of codeine phosphate, thereby would fall within the permissible limit as stipulated in the notification dated same notification, Lordship, and 1990, same, Lordship. As rightly held by the High Court, the said contention should have satisfied the twin conditions, namely that the contents of the narcotic substance should not be more than 100 mg of codeine. That is one aspect, Lordship, per dose unit, and with a concentration of not more than 2.5% in undivided preparation, apart from other condition, namely, now comes the important part, Lordship, the second condition, therapeutic practice. That I have already shown, it appears in the entry 35 also, Lordship. Namely, it should be only for therapeutic practice. Therapeutic practice, as per dictionary meanings, means contributing to cure of disease. In other words, the assessment of codeine content on dosage basis can only be made only when the cough syrup is definitely kept or transported, which is exclusively meant for its uses for curing a disease and as an action of remedial agent. Now, paragraph 13, Lordship.
In the instant case, they are saying that they are going to perform Hajj.
Yes, I'm coming
and
to that.
therefore
Then
they
Lordship
have,
will have to see the permissible limit. They can store, Lordship, but
okay,
within the permissible limit, Lordship. And if they are beyond storing it beyond the permissible limit, Lordship, I will narrate the facts. I will come to the case then, Lordship. Paragraph 13, Lordship. As pointed out by us earlier, since the appellants have no documents in their possession to disclose as to for what purpose such a huge quantity of Schedule H drugs containing narcotic substance was being transported, and that too steadily, it cannot be simply presumed that such transportation was for therapeutic practice, as mentioned in notification 14/11/1985 and 29/1/93. Therefore, if the said requirement meant for therapeutic practice is not satisfied, then in the event the entire 100 ml content of the cough syrup containing the prohibited quantity of codeine phosphate is meant for human consumption, the same would certainly fall within the penal provision of the NDPS Act, calling for appropriate punishment to be inflicted upon the appellants. Therefore, the appellant's failure to establish the specific conditions required to be satisfied under the above referred to notification, the application of the exemption provided under the said notification in order to consider the appellant's application for bail by the courts below does not arise. Now, Lordship, yes. So that is the main submission, Lordship. Another judgment, Lordship will kindly produce.
Vera,
Yes, here, Lordship, this is same issue, Lordship. Paragraph 9, Lordship will see. Regarding the issue that it's a manufactured drug, Lordship. Paragraph 9, Lordship. Lordship has found it.
yes.
Yes. In the arguments, much emphasis has been given by the learned senior counsel that section 21 of the NDPS Act prescribes punishment for dealing in manufactured drug in contravention of any provisions of the Act 85 or any rule or order made or conditions of license granted thereunder. Manufactured is defined in section 211 of the Act 1985. Clause B of section 211 of the Act provides that manufactured drug means any psychotropic substance or preparation which the central government may, having regard to available information as to its nature. Lordship is already aware of. Paragraph 10, Lordship, the same entry 35 is referred to here, Lordship. Methyl morphine regarding that is there. Paragraph 11, Lordship, the same submission regarding the concentration level. Paragraph 11, I am skipping all this, Lordship. Now, paragraph 12, Lordship, the same submission that it falls under Drugs and Cosmetics Act. Now, Lordship will kindly skip all this and kindly come to paragraph 17. Here also, Lordship, the judgment which I have just cited, it has also been cited here. Paragraph 17, Lordship will see. Earlier, there was some, this, Lordship, I have already given the notification at the outset, Lordship, regarding the whole percentage to be seen. Again, here it is mentioned, Lordship, earlier there was some controversy as to how the quantity of psychotropic substance found in any preparation or composition shall be calculated. But this controversy is now set at rest. The Government of India has issued a notification number so-and-so, dated so-and-so. As per note 4 appended at the end of the notification, it is made clear that for the purpose of determining the quantity, the gross weight of the drug recovered and not the pure content of the psychotropic substance shall be taken into consideration. Note 4 read thus. I have already placed that, Lordship. Lordship will now come to paragraph 19. One more judgment is referred to. I am skipping that. Paragraph 19, Lordship will see. These judgments are referred, but this relates to some psychotropic salt, Lordship, but the same proposition was considered in paragraph 19. Paragraph 20, Lordship, the Sahabuddin case, which I had just referred, is mentioned. And the relevant paragraphs I have already read of the Sahabuddin case, Lordship. That appears in paragraph 10, 11, 12, and 13, which I have already read out, Lordship. Now, Lordship will kindly come to paragraph 21. Paragraph 21, Lordship will find. Time and again, this court has followed the law laid down by the Honorable Supreme Court in Sahabuddin and Sanjeev Deshpande cases, so-and-so, that the gross weight has to be considered for calculation of commercial quantity. Paragraph 22. Thus, it is evident that the whole quantity of materials recovered in the form of mixture is to be considered for the purpose of determining the quantity of psychotropic substance, and when the psychotropic drug is kept in possession without any document to show that it was meant for therapeutic use and the gross weight of psychotropic substance is well above the commercial limit, the restriction contained in section 37 of the NDPS Act is directly applicable to the case of the petitioner. Nothing is on record to satisfy the conditions enunciated in this section. Next, let's see paragraph 23. Further, in the year 2015, the Government of India, Ministry of Finance, Department of Revenue issued a notification so-and-so dated 5/5/15. I could not get my hands on that, but it has been reproduced here and made codeine as essential narcotic drug. Relevant paragraph number 1 of this notification, it mentions, Lordship, that codeine is a
essential narcotic drug. Now, Lordship will see next page that chapter has been added, Lordship. A new chapter 5A is added in the Narcotic Drugs and Psychotropic Substance Rule 1985 by this amendment. For the sake of convenience, relevant rules of chapter 5A are being reproduced below. This has been reproduced, Lordship. 52A, Lordship will see possession of essential narcotic drug. No person shall possess any essential narcotic drug otherwise than in accordance with the provisions of these rules. Any person may possess an essential narcotic drug in such quantity as has been at one time sold or dispensed for his use in accordance with the provisions of these rules. 3. It also talks about the medical practitioner. A registered medical practitioner may possess essential narcotic drug for use in his practice, but not for sale or distribution not more than the quantity mentioned in the table below. So restriction is definitely there, Lordship. And Lordship will see number 2 point, methyl morphine, as has been mentioned, the quantity is mentioned as 2000 milligram. So basically, Lordship, just to sum up, Lordship,
2000 milligrams means how many bottles? 20.
2 liters probably, if I'm not wrong, Lordship.
2 liters is 2000 grams.
Milligram. I'll just point out, Lordship. I'll just next, Lordship will kindly come to paragraph 25, Lordship.
Next.
Paragraph 25.
Yes.
Thus, after May 2015, license to keep the composition containing psychotropic substance is made compulsory, and for the convenience of the persons traders already dealing in such psychotropic substances, 6 months' time was granted to obtain such license. The incident in the present case is so and so, but nothing is here to show that the petitioners has ever obtained or possessed any license requiring this law. Lordship, even the dealers, they also have to have a license, Lordship, and it has to be 6 months was granted to obtain such license. Next, Lordship, paragraph 28 for a moment. Down below, Lordship, will find the same.
Yes.
In any case, if we consider that the syrup containing psychotropic substance was in the permissible limit, Lordship, I am not admitting to that, but even if we held that it is within the permissible limit, even then, Section 8 of the Act 1985 provides that no person shall possess narcotic drugs or psychotropic substance except for medical or scientific purposes, or in the manner and to the extent provided by the provision of the Act or rules or orders made thereunder. Nothing is shown before this court that the seized contraband was stored or possessed for any therapeutic purpose. No documents whatsoever are produced by the petitioner. On the contrary, the contraband was concealed among the bags of potatoes and onions. So this reflects the case, Lordship. In paragraph 29 for a moment, Lordship, in Muhammad Shahabuddin, which I had earlier referred, Lordship, the Honorable Supreme Court has also discussed this issue and has held that apart from the other condition, it is mandatory that the contraband should be only for therapeutic practice. Therapeutic practice means it should be for medicinal purposes only, or should be exclusively meant for its uses for curing a disease and as an action of remedial agent. So, Lordship, yes, paragraph 30, Lordship. Lordship will finally, yes. At the cost of repetition, I can refer para 13 of the judgment, which says that as pointed out by us earlier, since the appellants had no documents in their possession to disclose as to for what purpose such a huge quantity of Schedule H drug containing narcotic substance has been transported, and that too steadily, it cannot be simply presumed that such transportation was therapeutic practice as mentioned in notification so and so. Therefore, if the said requirement meant for therapeutic practice is not satisfied, then in the event of the entire 100 ml content of the cup syrup containing the prohibited quantity of codeine phosphate is meant for human consumption, the same would certainly fall within penal provisions of the NDPS Act, calling for appropriate punishment to be inflicted upon the appellants. Therefore, the appellant's failure to establish the specific conditions required to be satisfied
under the above referred to notification, the application of the exemption provided under the said notification in order to consider the appellant's application for bail by the courts below does not arise. The observation of the Honorable Supreme Court reproduced herein above leaves no scope for this court to entertain the contention canvassed by the learned counsel for the petitioner, particularly looking to the quantity of bottles seized in the present case without any valid documents to justify the possession of such huge quantity of bottles. Now, Lordship, coming to the their contention that it was for medicinal purpose or whatever, if Lordship kindly takes up their petition. Lordship will straightway come to the forwarding at page 15.
Yes.
I'm sorry, Lordship, FIR at page 16, Lordship. I'm sorry. Lordship,
Yes.
page 16, Lordship, the second paragraph, Lordship, we reached Nur Alam Hussain house. Lordship has found it.
Yes.
We reached Nur Alam Hussein's house very at 12:20 AM. I briefed his family members about our arrival and asked them to search our body before entering his house. On thoroughly search of his house and premises of the house, from backside of the house nearby the bathroom, recovered the following articles in presence of witnesses. While the medicines were kept hidden in a black polythene near the bathroom. Next, Lordship will kindly come to the forwarding at page 17.
Yes.
Yes, Lordship will see grounds of arrest.
Yes.
Lordship will directly come to point 3. During course of investigation so far carried out, it is found that the arrested accused person is a habitual offender, as he was arrested earlier in connection to Bokolia PS case number 17/24, Botodrava PS case number 53/25, and Botodrava PS case 26/21 under section 21C NDPS. So he's a professional person. And Lordship, from this CD I am placing Lordship. Yes, just to point out that thing, on thoroughly search of his house and premises of the house, from backside of the house nearby the bathroom, found one black polythene, and in that polythene found so and so.
Okay.
And Lordship, this is under investigation so far, Lordship, and nowhere, Lordship, his statement has been recorded 4 or 5 times, Lordship. I know it doesn't have any field, but Lordship, nowhere he has stated about his parents going to Hajj, medicinal purpose. He has stated that he is a person who deals in drugs, Lordship. Just for argument's sake, Lordship. And if
Okay.
queries are there, Lordship, I will place the fact.
Mother, in this regard, what my learned friend placed before this honorable court, only one submission. Sahabuddin, he has referred, and regarding Sahabuddin, I have placed the judgment before this honorable court earlier also. Iqbal Singh Lordship, he replied that regarding the note 4, the contents, Lordship, that is describing Lordship, the manufactured drug defined in section 2.
Yes. Please don't repeat.
Lordship, that is
You
why,
have
Lordship,
already.
that is why, Lordship, this paragraph number, I'll place this one also. 16 and 17 earlier occasion I have not stated. Lordship, regarding this note 4, here discussed how it is applicable, and it is this.
In which Sahabuddin?
No. It in Iqbal Singh, Lordship. This is decided by the Delhi High Court. Lordship, it is here specifically mentioned why note 4 is not applicable regarding this bottles contains, Lordship, the percentage, because the notification not yet overrule or cancel, Lordship, but that was still prevail, Lordship. That is there, Lordship. So that is why, Lordship, this Sahabuddin is not applicable. Sahabuddin also discussed here, Hira Singh also discussed. In Hira Singh also it is mentioned in paragraph number 5.3, that the quantity of narcotic drug is also relevant for the purposes of determining whether a particular preparation is subject to the provision of NDPS Act or not. This is born out of clause 11 of section 2 of NDPS Act, which empowers the central government to notify a narcotic substance or preparation to either to be manufactured drug or to not be a manufactured drug. So that is exception is there. That is why, Lordship. And regarding Supreme Court, I have placed my Lord, I'll compile these things, Lordship, with a note.
Okay,
And-
when will you give?
Right now, Lordship.
Okay.
And one thing is there, Lordship, regarding this
Give by tomorrow. Tomorrow.
type copy, Lordship. Type copy.
Anything which is.
And this is whatever he has stated, that recovery is from the backside of the house, from the bathroom. But Lordship, he was arrested earlier at 4 o'clock. Why at that particular point of time not seize these things, Lordship? Why the persons of the family members not interrogated at that particular point of time? We have explained categorically the documents, medical prescription also we have annexed with the additional affidavit, Lordship.
Okay, okay, I'll go through.
Lordship.
Heard Miss S.K. Nargis, learned counsel for the petitioner. Also heard Mr. V. Sharma, learned additional public prosecutor. The learned counsel for the petitioner is requested to submit a written gist of her argument by tomorrow. Let this case be listed for delivery of orders on 25th of September, day after tomorrow.
Right.
Yes, we'll delete के रखें.
May I your Lordship? Lordship, here, backdrop of the case is such, Lordship. Pursuant to the affair, lodging of the affair, Lordship, petitioner approved this honorable court by filing AB number 3225/24. During pendency of that application, Lordship, charge sheet was submitted, and then the direction was given by this honorable court to apply a regular bail in the court below, Lordship. Accordingly, Lordship, petitioner appeared before the court below, Lordship. Page 20 is the order, Lordship.
Why the court rejected your prayer?
Court rejected. Here is the detail. No such ground has been cited. But Lordship, their perusal of the affair will justify that way that the case under 6 of POCSO has been attracted, Lordship. Page 12 is the affair, Lordship. Now he's under detention since 22/7/2025. Page 12, annexure 1 is the affair. May I read the contents, Lordship?
Yes, what you want to submit?
This the gist of acquisition is that, and if I read, it's not very Lordship
Yes.
long. Yes. The complainant begs to state that when the victim's age was 15 years old, studying at class 7 at that time, accused person promised her to make her legally wedded wife, and without her consent, forcibly took her virginity, and also she became pregnant. At the time of committing a aforesaid incident, accused person was residing in the house of the complainant. Thereafter, the accused person left the victim and took her to so-and-so Bora nursing home, Vishwanath Chariali, and forced her to abort. Thereafter, told her that he would marry her as per Muslim rituals and asked her to stay with her father and mother till then. Thereafter, the accused person, without marrying her, married another girl from Vishwanath and started conjugal life. Presently, also, he is continuing his marital life. On 26/9/2024, there the incident started, Lordship. 26/9/2024, the accused person issued the victim to marry her, and yesterday at about 4 p.m., accused person, with the help of his family member, assaulted the victim with the help of iron hands and legs, various parts of the body, causing mental and physical assault. With the help of false accusation, handed over her to Jijia police station at around 10 p.m.
The victim is presently at Jijia police station. The Jijia police station till now has not intimated the family member of the victim. Since the accused person has given assurance of marriage, therefore, some delay has been occurred in lodging the instant affair. The witness is ready to testify the truth. So this case has been lost. So basically, now what is my specific instruction, Lordship? On this day, the victim herself went to the place of the petitioner, insisted him to marry, Lordship. And finding no other way, there was some altercation in between. They, as a bona fide person, Lordship, they themselves, the petitioner here, the family of the petitioner, including the petitioner, took her to the police station, handed over her to the police station, that she is causing nuisance and this sort of things. Thereafter, Lordship, this instant affair has been lost, Lordship, just to cover up their scheme, Lordship. This is the fact. He's a married man, having no this is and whatever the incident they have.
You are a, what is your age?
Lordship, I'm 33 years.
You are a married person.
I'm just newly married, Lordship. 33 years.
Yes, Mr. Sharma.
Lordship, that is,
Victim has
I
not
have,
yet-
183 examination.
Yes, that is there. Otherwise, Lordship, the FIR is of 6/10/24. Charge sheet was submitted on 30/11/24, showing him as an absconder. The Lordship did not participate in the investigation, Lordship. Therefore, after the dismissal of his anticipatory bail in the month of January 25, Lordship, after laying of the charge sheet, he approached the court, Lordship. Then, Lordship,
The case is pending at the stage
at
of,
the stage of Lordship, charge framing, it was fixed on 29/8/25 for framing of charge. But what happened on that day is not before your Lordship.
yes.
and here, Lordship, para 4, I have stated, Lordship.
Let the victim be examined.
So now, Lordship, assuming Lordship, not admitting, assuming the fact, they are placing a correct fact in the affair, Lordship. That too, Lordship, they are stating that before 2 years, when she was 15, and then by now she is, Lordship, there's before they are explaining a story of 2 years before, whether that is admissible, Lordship. That is, and they are stating that the abortion and all, no document has been submitted before the police, Lordship. It was the fact, Lordship, it is admitted from the fact of the affair that they have, this petitioner and his family members took her to the police station because she was creating problem.
Okay.
And that is why,
Yes.
Lordship.
So Lordship, she has categorically stated in her statement, the victim has
183.
categorically stated the reason as to why she had gone to the petitioner's house. And your Lordship, it was only after she was assaulted that her parents came to know, her father came to know and her brother came to know. She had hid this from her parents out of fear, your Lordship. And then in the meantime, the petitioner, after the abortion, the petitioner got married to someone else. And after that, in these 2 years, he started harassing her.
Yes.
So which is why she had gone to the house of the petitioner, your Lordship. And that is why there's a delay in filing this FIR, because that is when the informant came to know about it.
That can be indulged, Lordship, to incident,
Okay,
assuming
okay.
the whole.
Okay, I'll go through the records. Scan copy of the records are there and pass the orders in chambers.
Certainly, he is a local person, he will abide by that, and to my instruction, she is also married to someone now.
I'll go through the statement of the victim. How she has implicated.
Lordship, that since the motives are not correct, Lordship, only because the refusal from the petitioner to marry her, this case has been delayed, that has to be taken into account.
Let me
Lordship.
go through.
That may be taken into consideration.
I'll pass orders in chambers.
If you oblige, Lordship.
Item 51.
Excuse your Lordship, this is your Lordship's last order, my lord. Initially, your lordship rejected that 6 out of 20 matter 6 were examined. Then your lordship said any other independent exam or not matter. After that, what I've not a single witness exam till today, my. Last year, lordship, what I reflected everything, my. What I did at 3/9/25.
Whether report has come,
There is an office note, Lordship. I could not go through the office note.
it is a POXO case.
No. Not.
302. 302, yes.
Not possible. Last exam, my lord, made on 26/3/25.
On what basis this order was passed that 6 should be examined?
No, your lordship, what am I can see?
Now, before that,
No, 3/9/23, your lordship. Idea that was rejected on the ground that he,
initially an order was passed
yes,
that 6 witnesses at least
right.
should be examined.
Still
Yes,
to the same position, man, same position. And that was on 6, was on 20. Last is, madam, yes, 26/3/25.
yes, Mr.
Lordship, I will have to go to the second copy, Lordship, because
When?
whenever your Lordship says, Lordship, because this is a case of 302, Lordship.
No, that is there, but.
That
My
cannot
lord,
be the only factor, Lordship.
But 20 witnesses,
The others
and
things-
they are sitting, my lord, sleeping over the matter.
You suggested it
As your Lordship directs, but going by the calendar, Lordship, it has to be.
after reopening.
My lord, 1 year, 4 months for this, my lord.
Matter of 15 more days. Heard Mr. H.R.H. Chaudhary, learned counsel for the learned senior counsel for the petitioner, assisted by Mr.
Alamgir.
Mr. M. Alamgir, learned counsel for the petitioner. The office note dated 11/9/2025 shows that the report of witnesses and the progress of the case pertaining to sessions case number 28/2024 has been received. And same is tagged as
57. 57 probably. 57. 57.
flag X. Putul record sound. Flag X. Stop. Learned. Additional public prosecutor submits that he has not gone through the scanned copy of the records and seeks some time for going through the same before he makes his submission. The prayer is allowed. Let this matter be listed on 22nd of October. 22nd of October.
I leave to lordship. Only madam, because today also he could have gone through that, madam.
On 22nd October.
Madam, I have item 57, my lord. Today is the last date, madam, so 57, in time till today, my.
57, you are on interim.
Yes, ma'am.
Interim granted by which court?
This court, this court. Your lordship.
We'll extend the interim for
Anytime, madam, I'm ready because it is here. Either before or after.
Yes, your Lordship.
you retain the case diary, extend the interim till reopening day.
Date may be so that
13,
1/3. Let it be on home, madam.
14,
14.
14th.
Obliged to loss.
Regarding other matters, I have a suggestion because many matters have left. There are many courts now assigned to take bail matters. I will request the registry to redistribute the matters among available bail courts.
Statutory appeal, my lord. Come for admission, so that may also be.
Everything, whatever is left over. So that the cases are equally distributed amongst the all courts which are taking up bail roster.
Lordship, item 53 is rejected by your lordship, so it is tied.
That will come to me.
Lordship,
Lordship, item 55, charge sheet might be submitted, more mentioned in the morning. Lordship. Okay.
56 also, my lord, charge sheet submitted, I am in interim.
I am also in it.
In the period of.
Interim will continue till I take up the matter.
Lordship, item number 9, in the morning, the other side CBI has taken time. And today.
No, when the matter was called for, you were not there.
My junior was
See,
there, my lord.
if a-
They have taken time, my lord. Can it be day after tomorrow, my lord?
Okay, day after tomorrow.
Lordship,
On
item
Thursday,
53 also day after.
No, not day after tomorrow. After
On
reopening.
Thursday, no, on
After
Thursday,
re-
my lord. We are inside more than 2 years, my lord.
So looking to the nature of.
Let it be on Thursday, my lord. If your lordship takes up, then it's okay.
No, let me not fix the date. Let the dates be fixed by registry.
Lordship, item-
Otherwise, similar problem will arise.
It can be taken up by a fresh case, my lord. It can be taken up by any bench, my lord.
Yes, so registry,
On Thursday, my lord.
no, registry will fix the date. I will make a request to the registrar.
Most of it.
Your case also.